One.
Good morning, everyone, and welcome to the August Oil, Gas, and Mining Board. We will start today with the briefing session, but just so everybody knows right up front, we are a few minutes late because we were talking about items number 1 and number 2 on the agenda, and both of those items have been withdrawn. So after reading those items into the record, we will go ahead and start with item number 3 on the docket, which is the Barrick Mining Corporation's docket, just so everybody knows that up front. So with that, let's go ahead with the briefing session. Mr. Thomas, thank you.
Good morning, Chairman, members of the board. My name is Mick Thomas. I'm the Director for the Division of Oil and Gas and Mining for the state of Utah. We've got a few things to talk about this morning in no particular order. I just want to remind the board and everybody involved that our September meeting will be on site in Vernal at the Uintah Energy Summit. Arrangements, logistics have been made by, frankly, Patty and members of our staff, and all seems to be green light. We will coordinate that moving forward. But then just a reminder, it's going to be September 23rd in Vernal. Second item, any questions? Okay, good, thank you. Second item, Critical Mineral Council update. As you may know, the Division of Oil, Gas, and Mining and myself as a representative is the co-chair for the Critical Mineral Council. We met yesterday to discuss a number of things. One of the big things, the first meeting we had, I guess a month or two ago, about a month ago, was to survey critical mineral operators to see what they may need out of the council and specifically the mine center. Deputy Director Dana Dean coordinated and executed a lot of those surveys. I did a little bit of follow-up as well. And the results were varied. We found that the specific needs for each operator had a lot to do with whatever their current business operations were and where they were logistically. For example, White Mesa down south and the Mariana copper mine needed extensive rail investment so that they could move their ore back and forth. So they really want rail, specifically 130-mile spur to Farmington, New Mexico. Well, that's a robust and needed request that is well beyond the division and probably the state. But we appreciate them sharing that. We're working with our federal partners moving forward. You guys know minimum that's a 10-year project because it's going to go through a number of tribal lands as well. There was a general consensus that, especially with the rural mines, they need diesel technicians, experienced diesel technicians and lab technicians who are eager and willing to commit to living in rural Utah over the long term. Generally, no shock. Oil and gas operators face this as well, but it's especially critical with our mining operators is finding people to work at the mines. Also the needed infrastructure, schools, roads, transportation. It's not unique to Utah. Any rural development resource in the United States struggles with that. On the flip side, these jobs pay very well, and a $100,000 a year job in San Juan County is a very, very good job to have because the cost of living down there is still significantly lower than what we see here on the front. Some of the other requests were the support and the establishment of a critical mineral market. Generally, the Chicago, Commodity Exchange and a number of others, we know what gold is selling for at any given time. If you're trying to determine the market price or the spot price for something like germanium, it's much harder. We have had a few people who've come to the division and the Governor's Office of Economic Development with some prospective plans on that. But setting up a new rare earth commodity market is significant, right? It's a global need, and I don't know that Utah would be able to help a lot there, but definitely we would definitely not get in the way of that. More importantly, or actually something else that we could probably do, the board and the stakeholders are aware of the need and the drive for permitting and regulatory update and modernization within the state of Utah. They asked for us to continue that endeavor to continue to work to develop a cooperative agreement with our federal partners so they can have a one permit approach. That is one of the main drivers and goals of the division this year. Tomorrow, actually this evening and tomorrow, I'm meeting with the Chief of Staff and some others for the Senate Natural Resource and Energy Committee in D.C. to discuss this permit reform and this unified cooperative agreement. Anything with the feds is complex, right? But it's moving, right? It's moving along. We're happy about that. And finally, there was a specific request for assistance in the development of a Department of Energy grant for rare earth elements, specifically heavy rare earth elements, in the in the over and underburden above the coal seams in Utah. The University of Utah has provided and done some research and shared their findings that the top 2 or 3 feet and the bottom 2 or 3 feet below the coal seams in Utah are a marketable source of rare earth elements. I think the positive there is the infrastructure, the labor force, and the equipment needed to extract these REEs are already in place because they're already bringing coal out of the rock. I'm not going to put them ahead of some of the other REE projects that we have in the state, but it should provide a significant an advanced position for some of our coal operators to further monetize their operation. That's very preliminary, just came in last week, but maybe I'll bring it up. I hope to bring it up tomorrow with our discussion with the Natural Resource Committee, and that was generally our input, the OGM's input into the Critical Mineral Council meeting. We had lengthy conversations with the University of Utah president, Taylor Randall, to continue to collaborate on some of the research that they're doing. But it's a productive meeting, it's a productive council, and we are taking good steps, which is a good sign. Any questions on the Critical Mineral Council update?
Yeah, on the permitting process, is there anything different about critical minerals permitting than just hard rock mining or coal mining? Okay.
No.
So we got one procedure that works for everybody.
It boils down, and Chairman, members of the board, you're aware of this. We have small mine permits and large mine permits, and it's, if it's hard rock, a metal, then that falls underneath Dana Dean and her programs.
Mm-hmm. Okay. Other questions? Go ahead.
Well, I'd just like to add that I know you've been working with the BLM on one-stop shopping for permitting, and when it comes to various tribal BLM, it'd be great if DOGM, if the division could be a one-stop shop for all of that. Not only in critical minerals, but in other hard rock.
Thank you, Chairman, and Mr. Galecki. Again, for the record, I want to say we're not seeking any sort of primacy over anything on federal land. We're simply offering DOGM resources to vet applications as they come in, so that when we do give them to our federal partners, they are complete and accurate. That, I've been told, could reduce federal permitting time from 5 to 10 years down to a couple, which could bring the United States into at least a competitive posturing for all other nations.
Well, I know Associate Director Dean worked in as far as the initial response, for permitting, especially in coal, which makes a big difference whether it passes that first hurdle. And so that type of thing would be great.
Thank you.
Quick question on NEPA. How are you getting around all the NEPA requirements for the permitting process?
That's a great question. I appreciate that. The NEPA process is not part of the state process, right? And I think that is not included in our cooperative agreement with the feds currently. The DNR as a whole, beyond DOGM, DNR as a whole has staff who could assist there. But that conversation is happening, but we don't have anything ready yet. I think ultimately, if it could be anything, we just give good, solid information to them, and they can make the decision. Our federal partners have said repeatedly they are significantly understaffed, especially for botanists and biologists and the other people who do those NEPA studies. Factor in the political variations of the current administration versus the potential next administration. And again, I'm not forecasting anything, but there's a significant unknown there.
Yeah, I know that there's been significant discussions under this current administration to try and figure out how to streamline NEPA or bring it back to its original intent so that it doesn't become a process where you're managing public lands for lawsuits, for example. So it's really a procedural rule rather than something that it's grown into. So
thank you. Actually, that's a bit of information there. We spoke with one of the senior Utah federal senators about this, and the Senate, at least on both sides of the aisle, understand the need for modernization. We learned that the NEPA model has been used by a number of our national, partners throughout Europe. The one significant difference of the U.S. versus, I think, any other nation that's using that model is they have a limit on how long a litigation can go on or how long a permit can be deliberated over NEPA, something like 180 days to 3 years. And that is obviously a game changer. And it's a unique situation in the United States that litigation can go on into perpetuity.
Okay.
Thank you.
Anything else? Okay, go ahead.
Next, I'm very happy and excited to introduce Deputy Director Dana Dean, who has been traveling, representing the state exceptionally well, and I invite her to come up and give us an update.
Good morning, Chair, board members.
Good morning.
I've been asked to speak about a trade mission that I was recently involved in to Argentina. We had the Commissioner of the Governor's Office of Economic Development, Jefferson Moss, Franz Kolb, who works for Jefferson as he's been with the Governor's Office for 35 years doing diplomacy and international relations, Commissioner Joel Ferry, Senator Darren Owens, and Representative Casey Snyder, and myself. And I was there because we were talking about mining, and I've lived in Argentina and speak Spanish, and that was very helpful. You wouldn't believe how far just a little bit of Spanish and saying, hey, I know your country gets you. But we had a lot of great meetings. It was a very packed schedule. We met with people in Buenos Aires who are part of the federal government, several senators from around the country, business people. Then we visited the province of Córdoba, where we went to Mar Chiquito, which is a terminal lake, much like the Great Salt Lake. Mm-hmm. And the key thing there is there's a bird called the Wilson's phalarope that flies. It lives on the Great Salt Lake. I believe it has its babies here, but when it arrives at the Great Salt Lake, it weighs 4 ounces. Over the time it's here, over the summer, it gets to 8 ounces, and then flies 7,000 miles without stopping to Mar Chiquita, where by the time it gets there, it's down to 4 ounces again because it used up all its energy flying that far. But that's a very important bird that is potentially is on the list for potentially being listed as an endangered species. We would like to prevent that like we did with sage grouse. And we're working on an accord between the province of Córdoba and the state of Utah that we think will help with that. Joel Ferry is heading that up, and he was very interested in that issue, and that was one of the reasons we went to that place. We then went to Jujuy, where they do a lot of brine mining, similar to the Great Salt Lake, but also with wells. And we talked to people there about terminal lakes and brine mining and technology. It was a very successful visit. We also spoke with people from industry. We had 2 receptions where total, I think we had over 400 people coming and just wanting to get to know us and begging us to come back and do more and have more meetings. So during the trip, though, we signed 2 MOUs. I didn't sign anything. The governor's office and DNR signed 2 MOUs, one with the province of Catamarca and one with the province of Jujuy. They're working on one with a newly created nuclear regulatory commission. They've had nuclear energy in Argentina for years. And so traditional nuclear, they have all of the skills, all of the knowledge. They have the biggest Spanish-speaking knowledge base on nuclear energy. But in the last year, they created a new commission that will oversee nuclear energy from cradle to grave, much like our nuclear campus that we're working on with the Department of Energy. So they are very interested in signing an MOU with us. That's being worked on right now. And the MOU, like I said, about the with Cordoba, which will include that bird, is also being worked on. And these MOUs covered mining, tourism, education, everything that the other provinces wanted to meet with us about. We talked to a lot of people and asked if other states had been down there trying to do similar things. They had not. So Utah has a good opportunity here to connect some of our industry with industry down there. They have some technology that we don't have. We have some technology that they don't have. And so it's very good to have that connection, and they're not just looking for investment one way from the United States to Argentina. They're looking at companies from Argentina investing in the United States and expanding in the United States as well. So it was a very good mission. Would love to go back if asked, but I think the people organizing it, the Governor's Office of Economic Development, did a great job setting up meetings with the right people. And again, we had a very successful writing up 2 MOUs and 2 more on the way that will have a good impact on the state of Utah.
Okay, thank you. Any questions, board?
Could you tell me the name of that bird again?
The Wilson's phalarope.
Thank you.
I can send you an email about it. Actually, it was interesting because we wanted to take a group picture, and we were coming back on the bus that was taking us back to town. And we saw this big mural. There's a mural on a wall, and it shows the bird. It's like a big picture of the bird, but then it has a map of the Americas, and there's a dot in Utah and a dot in Argentina, and it was just kind of serendipitous that we saw that, so we took a picture in front of that. But yeah, the Wilson's phalarope, it's an interesting bird. But then you think about all the other birds that do the same thing, and so anyways, thank goodness Joel was there because he knows a lot more about birds than I do. But
Thank you.
yeah,
Okay. Anything else? Thank you. Thanks a lot.
thank you.
Thank you, Dana. I was really hoping you'd do the whole thing in Spanish, but we appreciate your English, so that's very helpful. You're also the next item on the agenda.
Okay, is this the minerals fees? We need to have a public announcement that we want to raise our fees for the minerals program, and this is the method that we're doing it. The fees for minerals permits have not changed in at least the last 20 years. They're fairly low. Right now it's $150 for a small mine permit or an exploration permit, $500 for a large mine permit up to 50 acres, and $1,000 if you're over 50 acres. So Kennecott's paying $1,000 a year for our permit fee. So we thought we'd modernize that a little bit, but the main reason that we're asking for a change in fees, what kind of spurred us to ask at this point, is we are adding brine wells. The brine statute passed the legislature last year. The brine rules will be coming before you for formal rulemaking soon. We're in the informal rulemaking stage right now, getting comments from all parties. But we need a new fee for a brine well. And so we will be adding that type of permit. and then increasing the fees. Sorry, I didn't know that I was on here. I think we doubled all of the current fees, and then we're asking for $1,000 for a brine well.
I got a quick question. Do you
Yeah.
have any idea when's the last time they were increased?
It was, I think, in 2003 when the division got enforcement power over small mines, because before that we had small mine permits, but there was no, you couldn't write a violation to them. So I think around 2003.
Yeah.
Okay, so this is a initial public notice. Are we going to file a request for agency action or something like that later in the year to approve these fees, or just?
No, we're not required to have a request for agency action. We have to have a public notice. This is the public notice. If someone wants to comment, they can. This will also need to go through the legislative process. That's where they'll get approved. We'll give our new budget to the governor's office probably this month. And then if the governor approves the new fees, then the legislature will have to approve the new fees. So there will be several more public opportunities for people to comment, but we had to start with a public declaration of our intent.
Okay, so this is months away from
Yes,
being negotiated.
Yes, the end of March would be when they could be approved, and then things usually, I would assume that they wouldn't take effect until July 1st of next year.
Okay. Okay. Board members, any questions on this matter? Okay, thank you.
Thank you.
Thank you, Dana. As all of you are well aware, we have 2 exceptional deputy directors in the division. And Dana just shared why she is very talented and urgently needed here. We appreciate her representing the state internationally. I know she has gone to Canada and did an exceptional job there, and the feedback I'm getting about her participation in Argentina has been consistently stellar. So we definitely appreciate her commitment there. While Dana was gone, Director Thomas was able to lead a legislative tour, which probably gave her some heartburn, but we all did fine, and everybody made it back with all their fingers. We visited we took a delegation of state management, different divisions, the Governor's Office of Economic Opportunity, Economic Development, and the Office of Energy Development, and a number of others. Staffers, plus 2 legislators, Senator Winterton and Representative Stevenson went down with us as well. We visited the White Mesa Mine and the Velvet Wood Mine. And generally, this is where we got some of the best feedback on the needs that I shared with you earlier. It's interesting, both of those mines and pretty much all of the active mining operations in southeast Utah have a solid business plan and a profitable goal. They simply need infrastructure. Right now, the White Mesa mine specifically is operating about 50 to 60% of its capacity, and they're going to add a second. They're probably going to double their capacity to handle some additional REEs, rare earth elements, but their infrastructure to move the ore in is tight. A 1% concentration for a uranium ore is high grade, is very marketable grade. And you all know it costs a lot more to bring in ore. It's harder to pencil that out versus taking a refined product and then moving it elsewhere. So they really need that infrastructure investment, and the state will do all it can to help there. But the tour went very well, and we had a lot of good feedback. And as much as anything, these tours are about education and building relationships so we can move the ball faster. Any questions about that?
Board, any questions? No. Thank you.
Thank you. Next item is other. I don't have anything specifically to answer, but if you have any questions, I'm happy to discuss.
Anybody got anything else that they want to ask Mr. Director Thomas? Okay, go ahead, Mr. Thomas, then.
Thank you. Finally, a reminder again, next month's agenda and division calendar is going to be September 23rd in Vernal. I think a number of you are going. We have accommodations for our legal counsel as well as board members and a few staff, and so we'll see you then. And that's all I have.
So as of right now, there are some hearing examiner issues on the docket. And
That's right.
there are 2 or 3 other items too. So it will be, not just a short hearing, it'll be a regular hearing.
And I think board counsel knows this. Counsel has to be in person for these meetings. Witnesses and other people do not. So we may have a couple of witnesses who join remotely, but Matt Morgan has it well in hand, so it should be effortless.
Okay. Thank you, Director Thomas. Okay. So that completes the briefing session. We now have an opportunity for public comment. So are there any members of the public that want to make any comments at this time? We'd like to welcome you to come forward. Matt, is there any public comment parties online?
There are no public comment parties online.
Okay, so we will just go ahead and proceed then with the formal session. Thank you, Director Thomas, for your time. Okay, and as I said earlier, the first 2 items have been withdrawn. Okay, so docket, and we will be beginning with agenda item number 3, which is the Barrick Mining Corporation's docket. So if you guys want to start shuffling up, you're welcome to do that. So on item number 1, in the matter of the request for agency action of Arch Uintah LP for an order requiring an accounting and payment of proceeds from Coda Resources, including Coda Uintah LLC and affiliated operating entities. I've received a written or an email from Robert Anderson of Arch Energy Partners requesting or recognizing that with the help of the division staff, Brittany in particular, they are able to resolve their issues with Coda, and they have removed or they have requested withdrawal of their petitions on docket number 2026-030, cause number 479-03, and docket number 2026-31, cause number 479-04. Now, I don't know if Mr. Anderson's here or if there's anybody from Coda here to confirm that, but we'll take that as, and it was just given to me by council, so we're good. All right, so item number 1 is withdrawn. And item number 2, I'll read it into the record. Docket number 2026-031, cause number 479-04, in the matter of the request for agency action of Uintah Minerals Holding, LLC, for an order requiring an accounting and payment of proceeds from Coda Resources, including Coda Uintah LLC and affiliated operating entities. Agenda item number 2, or docket number 2026-031 has been withdrawn. With that, we will move on to agenda number 3. Give me just a second. Okay, agenda item number 3 is docket number 2026-036, cause number M0450017-BT, in the matter of Barrick Mining Corporation's request for agency action to terminate board-approved self-bonding and indemnity agreement and reclamation contract for the Mercare mine. Let's take appearances.
Michael Zodi with Parsons, Bailey, and Latimer on behalf of Barrick, and I have Kevin Hamatake, a consultant with Barrick, present with me as well.
Okay. Division?
Assistant Attorney General Gary White here on behalf of the Division of Oil, Gas, and Mining, and I'm seated to my left is Division Expert Brian Rue.
Okay. Okay, great, thank you. Okay. Mr. Zodi, please proceed.
Yeah, good morning, Board Chair and board members. This should be hopefully a fairly simple exercise. Barrick Mining Corporation, my client, used to own the Merker mine in the Ochre Mountains. It's been in reclamation for many years. That mine was sold, Barrick's interest in that mine was sold to Revival Gold, and the name of the mine now is Merker Mines LLC, and that's the interests in that are owned by Revival Gold. As part of that transaction, the notice of intent, the permit for the mine, has been transferred to the name of Merker Mines LLC, and Merker Mines LLC has entered into a new modern, if you will, reclamation contract with the division, supported by a third-party bond for reclamation of the mine. So Barrick is out of the picture. It's no longer owning it. The division has approved the reclamation contract, the new reclamation contract. It's reviewed and approved the bond. And Merker and Revival Gold are undertaking new exploration and trying to bring that mine back into operation. We are here today because, as you can tell from the papers that we filed, Barrick Mining Corporation and predecessors had entered into a contract with this board, as was allowed and is allowed under the rules, to self-bond the reclamation obligation. And so there's what I would call an old, if you will, a vestige of a reclamation contract and self-bond with this board. And we're here today to ask you to simply terminate it, because Barrick no longer owns the mine. There is a new bond and reclamation contract in place. We've gone through all of the procedural steps. We've worked very closely with the division, and I want to thank the division and Deputy Director Dean and Counsel Gary White and the rest of the staff. We worked closely to coordinate how to go about this process, have followed the correct rules and procedures. We've presented all of the information to you in our papers. There's a lot of paperwork, but I think I've summarized the nut of it. The division has filed a non-objection and recognized the new bonding is in place. And so the ask is simply for you to terminate the old reclamation contract and self-bond. It's no longer needed. You have full protection. The state has full protection with the new operator and a new bond. So that is the ask. I could go into a lot more detail about the history, but I don't think we need to today to get to the outcome that the paperwork and the law supports. So that's my presentation. I'm happy to answer any questions. Thank you.
Okay. Okay. So we have all these exhibits and evidence, and so we'll just keep moving forward with that. Did you want to proffer or have your witness make any statements or anything like that, or is
No, thank you. Mr. Hamataki is here for representation, but all of our information necessary for your decision is in the paperwork in front of you. Thank you.
Okay. Okay, division?
Thank you, Chairman Walker. The division has reviewed the request carefully, and as council correctly stated, there were many meetings. Barrick worked closely with the division during this transfer and change, and there is new bond at the mine. So the division accepts the proffer that was offered today as accurate, has reviewed the request and the exhibits, and has no objection to the board granting this request and formally terminating the board-approved self-bond.
Okay. So I think it's, does the board have any questions of either the attorneys or the witness that's here, or witnesses that are here? Okay, let's entertain a motion then.
I'll move that we approve the RAA or the change in the bond as presented.
Okay. Okay, motion's been made and seconded to approve the request for agency action and terminate the bond as requested. All the exhibits have been given to us previously, and they're all here, so no need to enter those as evidence. All those in favor say aye.
Aye.
Any opposed, say nay. Okay. Please, who will prepare the order? Okay, please go ahead and prepare the order, and we'll proceed.
Thank you, Mr. Chairman. Thank you, Board. Appreciate your time this morning. We will get the order to you and coordinate with the division in doing so.
Okay, thank you very much.
Thank you.
Thank you.
Okay. Okay, so we'll be moving on now to agenda item number 4. While Mr. McDonald's getting set up, I'll go ahead and read this into the record. But before I start reading this into the record, Mr. McDonald, I want to make sure that I'm reading this properly and that all the items under Section 1 and Section 2, all the sections are within Township 4 South, Range 2 West, and that I'm reading this properly and understand that properly. Okay. Okay. Okay, agenda number 4 is docket number 2026-037, cause number 130-53. In the matter of the request for agency action of 4 Point Resources, LLC, for an order 1, establishing overlapping stand-up vertical drilling units for extra long lateral horizontal wells for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of Section 1, 12, 13, 24, and 25, and Sections 2, 11, 14, 23, and 26, respectively, with certain caveats related to existing wells thereon, and 2, establishing overlapping drilling unit boundary well drilling units for extra long lateral horizontal wells for similar production along common boundaries comprised of Sections 1, 2, 11 through 14, and Sections 23 through 26, and Sections 2, 3, 10, 11, 14, 15, 22, 23, 26, and 27, respectively, all in Township 4 South, Range 2 West, USM, Duchesne County, Utah. We'll take appearances for council.
Fred McDonald of council with Lear & Lear on behalf of the petitioner, 4 Point Resources, LLC.
Thank you, Mr. McDonald.
Good morning, Mr. Chairman, members of the board. My name is Nico Micheletti, Assistant Attorney General on behalf of the Division of Oil, Gas, and Mining. Sitting to my left is Division Expert Regina Echo. Thank you.
Thank you.
Having a little bit of trouble with my PowerPoint, if I could have
Go
a few
ahead.
more minutes.
Yeah, go ahead, Mr. McDonald. Okay, we'll need to swear in their witnesses when the time comes.
Okay, we're ready now, Mr. Chairman.
Go ahead, Mr. McDonald.
Thank you. With me today, testifying on behalf of the petitioner, Mr. Clint Cook, Senior Landman, Ms. Sarah Smaltz, Geologic Planning Manager, and Mr. Brent Kovach, the Senior Reservoir Engineer. They're appearing virtually pursuant to the board's August 13th order. I would ask that the Vice Chair swear them in at this time.
Would you please raise your right hands? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Thank you. The resumes of all three witnesses were collectively submitted as Exhibit A. If separately asked, each of the witnesses would verify that the contents of the resumes are true and correct. Mr. Cook will be a fact witness only. Ms. Schmaltz and Mr. Kovach have been previously recognized by the board as experts in geology and petroleum engineering, respectively. Presuming the division has no objections, we again request that they be recognized in those disciplines for purposes of this cause.
No objection.
Okay. Board, any questions? No? Okay, proceed.
And as usual, I will be moving for admission of our exhibits at the end of our presentation, Chief. Members of the board, 4 Point is before you today seeking establishment of 2 overlapping stand-up drilling units for 20,000-foot well development of the Lower Green River Wasatch formations, comprised of sections 1, 12, 13, 24, and 25, and sections 2, 11, 14, 23, and 26 of Township 4 South, Range 2 West, in the Uintah Special Meridian, respectively. Sections 25 and 26 are partial sections resulting from the Uintah Special Meridian boundary line and are included to avoid stranding development of them. As the board is aware, 20,000-foot horizontal wells are the latest trend of development in the western portion of the Uintah Basin. There are several existing wells upon these lands as identified in the request, pursuant to which production is allocated pursuant to the board's 139, 150, and/or 130-09 orders. However, since the requested drilling units are overlapping, there will be no further conversion and therefore no disruption to the existing production allocation schemes. 4 Point is requesting the same caveats regarding the requested drilling units as has been previously imposed by the board for 20,000-foot wells, for example, the recent 130-48 order, including no interwell setbacks between the existing wells and newly drilled 20,000-foot wells. As the testimony will show, the owners of the correlative rights in those existing wells actually benefits from new 20,000-foot wells by, first, uptick in production, and second, ultimate economic recovery of the resource. Furthermore, no interwell setbacks is the trend adopted by the board in the Uintah Basin, specifically as outlined in the 130-48 and most recently in the 130-52 orders. The board has already recognized the elimination of these interwell setbacks does not adversely affect or impact the adjacent existing wells. Additionally, 4 Point seeks establishment of overlapping drilling unit boundary well drilling units along the common boundaries of these 20,000-foot drilling units, and with sections 3, 10, 15, 22, and 27 of the same township, with similar caveats as the board has previously adopted and is outlined in more detail in the request. Sections 3, 10, 15, 22, and 27 have already been established as a 20-foot drilling unit pursuant to the 130-48 order. True and correct copies of the 139, 150, 130-09, and 130-48 orders, as well as the board's 600-03 order, which modified the 139-150 order to reduce the heel-toe setbacks from 330 feet to 100 feet, were collectively submitted as Exhibit B in this cost. Since Indian mineral lands are involved, new communization agreements are required, and the agencies, whether under federal guidelines or by practice, require a spacing order from the board for such communization agreements to be approved. This is another reason why 4 Point is before you today. The board has jurisdiction over this matter pursuant to Utah Code sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the newly requested drilling units, including the Ute Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, and the Bureau of Land Management due to the Indian ownership, and to the School and Institutional Trust Lands Administration due to state ownership. The mailings were sent to these parties at the last addresses disclosed by the relevant agency records and the Duchesne County Realty records. In addition, notice of the filing of the request in this hearing was also duly published in the Salt Lake Tribune on August 2nd and in the Uintah Basin Standard on August 5th. On August 10th, the division filed a response generally expressing no opposition to the granting of the request, presuming 4 Point meets its burden of proof at today's hearing, which we will do. No other objections or responses to the request were timely filed, and no other party has made an appearance here today. With that, I'll commence my examination of Mr. Cook. Mr. Cook, would you please state your name and business address for the record?
Yes, Clint Cook, 4 Point Resources LLC, 100 St. Paul Street, Denver, Colorado, Suite 400.
And what is your position with 4 Point, and how does it relate to this request?
I'm a senior landman overseeing the DSUs at issue.
All right, would you please, for the record, state the corporate and bonding status of 4 Point?
Yes, 4 Point is Delaware Limited Liability Company with its principal place of business in Denver, Colorado. It is a successor by assignment to Veniv USA Inc. 4 Point is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all the relevant state of Utah agencies.
All right, I'm going to show you what have been marked as Exhibits C through H for purposes of this hearing. They're shown on the PowerPoint. I believe you also have a hard copy in front of you. Do you recognize these exhibits?
Yes,
Were they prepared by you or 4 Point personnel with your review and input?
they were.
Turning your attention to Exhibit C, would you please explain what this shows?
Yes, this is a regional locator plat showing the DSUs at issue are approximately 1.5 miles due south of the Mighton town site and US 40.
All right, now turning your attention to Exhibit D, this is a 3-page exhibit. Starting with Exhibit D1, please explain what this shows.
D1 reflects the existing DSUs under the current 139-150, the 130-09, and the 130-48 orders.
Now turning to Exhibit D2.
Yes, this shows the proposed DSUs, reflects the requested new overlapping 20K DSUs for the XL horizontal wells.
And finally, D3.
D3 reflects the requested new overlapping drilling unit boundary well DSUs.
Now turning your attention to Exhibit E, please explain what this shows.
Exhibit E is a mineral ownership type plat showing the Indian minerals in green, the Sitla minerals in blue, and Fee minerals in yellow.
All right, what is your understanding with respect to the federal agencies when it comes to communitizing Indian lands?
Yeah, when Indian minerals are involved, a spacing order facilitates and is required by the BLM and or BIA for approval of the conforming communitization agreement, whether by their guidelines or actual practice.
Now turning your attention to Exhibit F, please explain what this shows and its significance to today's hearing.
Yes, Exhibit F shows the working interest in each of the DSUs, displaying that 4 Point is the clear majority working interest owner in all the existing DSUs and therefore all the requested new DSUs and drilling unit boundary well DSUs. The board already additionally found that 4 Point is majority working interest owner under the XL horizontal DSU established under the 130-48 order.
And, okay, and then turning your attention now to Exhibit G, please explain what this shows.
Yeah, G is just a plat of the existing wells, showing that existing well production allocation is previously converted per the 139-150 and 130-09 orders to the 2-sectional DSU basis.
And finally, turning your attention to Exhibit H, please explain what this shows and its significance to the hearing.
Yes, this is a table of the current production allocation showing that all existing wells will remain on their existing allocations provided under the 139-150 and 130-09 orders. The requested DSUs will overlap. Consequently, no additional conversion will occur.
Okay, now I'm going to ask you to pull up the certificate of service that in this matter, that's a pleading already on file that was prepared by my office. You should have a hard copy to look at. Who are the parties that are shown on that certificate of service?
These are parties and addresses that were compiled by 4 points, internal land records, including title opinions and search of the BIA, Sitla, and Duchesne County records prior to the filing of the RAA by Lone Wolf Energy, who is 4 Points contracted land service company.
Were any parties outside of the requested drilling units notified, and if they weren't, why?
No, they weren't, because we're not requesting any change to the setbacks.
All right, and again, once again, how were those names and addresses compiled? You had a search done of the records?
Yes, yeah, we did a search of our internal land records, title opinions, county records, BIA, Sitla, all done by Lone Wolf Energy.
Which is your contract broker, correct?
Correct.
For the board's representation, again, they were mailed out regular mail and not certified mail, so there's no Exhibit Z that you're used to with the return receipts. With that, Mr. Chairman, that concludes my examination of Mr. Cook.
Division, any questions?
No questions for this witness.
Board, any questions of Mr. Cook? Seeing none, go ahead and proceed.
Thank you. I'll commence my examination of Ms. Schmaltz now. Ms. Schmaltz, would you please state your name and business address for the record?
Yes, Sarah Schmaltz, 4 Point Resources LLC, 100 St. Paul Street, Suite 400, Denver, Colorado 80206.
And what's your current position with 4 Point, and how does it relate to this request?
Yes, I'm the geologic planning manager for 4 Point Resources, overseeing the DSUs that are at issue today.
I'm going to show you what have been marked as Exhibits I through K. Do you recognize these exhibits?
Yes.
Were they prepared by you or 4 Point personnel with your review and input?
Yes, sir.
Turning your attention to Exhibit I, would you please explain what this shows and its significance to today's hearing?
Yes, on Exhibit I, the map highlights the location of the proposed DSUs in relation to the field type log, the Shell Brotherson 1-11B4, which has been used and recognized in numerous orders, including the 139-150, the 130-09, and the 130-48 orders. On the left-hand side, you can see that the stratigraphic interval, which is defined as the lower Green River to Wasatch transitional formations, is highlighted on the left side of the type log.
Now turning your attention to Exhibit J, please explain what this shows.
Yes, Exhibit J is displaying a type log within the area at issue today. This is the Allen Trust 7-24. It is highlighting the primary target intervals for the area and for the 20,000-foot wells that may be proposed in the subject DSUs.
And finally, turning to Exhibit K, please explain what this shows.
Yeah, Exhibit K is a north to south stratigraphic cross-section through the DSUs we're talking about today, including the local type log from the previous exhibit. This cross-section reflects the uniformity of the primary target formations, which makes these units conducive to 20K development in this area. This also highlights that the lower Green River to Wasatch transitional formations constitute one common source of supply in the area and is consistent with the board's designation of those formations as one pool throughout the Uintah Basin.
So it is your, excuse me, is it your expert opinion then that the uniformity and thickness make the lower Green River Wasatch an attractive target for 20,000-foot well drilling?
Yes, sir.
Is it also your expert opinion that the lower Green River Wasatch constitute one common source of supply in this area?
Yes.
That concludes my examination, Ms. Schmaltz, Mr. Chairman.
Division?
No questions for this witness.
Board, any questions? No questions.
Okay, I'll commence my examination of Mr. Kovach. Mr. Kovach, would you please state your name and business address for the record?
Yes, it's Brett Kovach and 4 Point Resources, 100 St. Paul Street, Suite 400, Denver, Colorado 80206.
And what's your current position with 4 Point, and how does it relate to this request?
I'm the senior reservoir engineer overseeing the DSUs at issue.
All right, can you confirm for the board the findings that the board made in the 13048 order regarding elimination of interwell setbacks and the fact that it doesn't adversely affect the owners in the existing wells?
Yes.
Could you also briefly address again what steps are taken to protect the existing wells during drilling completion of a new 20,000-foot well?
Yeah, so, both during drilling and prior to drilling, we do a good amount of anti-collision analysis and, intentional steering while drilling to minimize risk. And then during the completion operations, frequently we'll shut in offset wells during frac to ensure and frac protect those wells, kind of build up the pressure there.
All right, I'm going to turn your attention to Exhibit L. Do you recognize this exhibit?
Yes.
Was it prepared by you or 4-Point personnel with your review and input?
Yes.
Okay, would you please explain to the board what it shows and its significance to today's hearing?
Yeah, so Exhibit L is comparing the economic benefits of a 2-mile and a 4-mile well. So just a couple things to point out here. When we kind of look at the performance of these extended laterals, like the super long laterals relative to the 2-mile wells, you can see from a recovery perspective that really we're expecting to recover 2 times the oil. So we're seeing that production scale quite well. And then when we look at the well cost, and particularly the well cost per foot, I think is a good metric to focus on here. When you go from drilling a 2-mile well to a 4-mile well, you generally see a cost reduction on a per foot basis of around 22%, which, really that leads to more oil recovery for less cost in the ground. And you can see from the PVs and the IRRs that there's an outsized boost here when you go from 2-mile to 4-mile wells. So it's really a highly commercial strategy for us to maximize recovery of resource in the basin.
Okay, the request asks for up to 40 aggregate 10,000 and 20,000 foot wells. Can you explain where that number came from and why you're asking for that as well?
Yeah, so that's what was allowed under Order 13048, and so we're really seeking the same authorization here. And we feel that well count provides us the right amount of wells to ensure that we maximize resource recovery out of these DSUs, and ensure that we can maximize that recovery in additional formations as we continue to delineate the basin.
All right, and again, I'm sure the board is well aware of this, but just a brief explanation as to why the drilling unit boundary wells are needed.
Yeah, so given our understanding of the drainage profiles of these wells, that drilling unit boundary well really enables us to maximize recovery and avoid wasting that resource between units that would not be drained otherwise.
All right, is it your expert opinion that up to 40 aggregate 10,000 foot and 20,000 foot wells may be required to recover additional resources in each of the requested drilling units which would otherwise be left in the ground?
Yes.
Is it also your expert opinion that the 100-foot heel toe and 560-foot perpendicular setbacks will not adversely affect the correlative rights of adjacent parties?
Yes.
Is it also your expert opinion that the 20,000-foot wells appear more economic than the 10,000-foot wells?
Yes.
Is it also your expert opinion that drilling boundary wells are needed to recover resource between adjacent drilling units?
Yes.
And finally, is it your expert opinion that the elimination of interwell setbacks between existing wells and new 20,000-foot wells in general benefits rather than harms the correlative rights of the owners in those existing wells and is consistent with practices in other basins, including the Uintah Basin?
Yes.
With that, Mr. Chairman, that concludes my examination of Mr. Kovac.
Okay. Division, any questions?
No questions from the division.
Okay. Board, do we have any questions of Mr. Kovac? Go ahead.
Better have one question for you guys.
Yeah.
How many of these 4-mile horizontals have you drilled? And I would think that there would be a higher risk the further out you go. But you're not seeing that, is that correct? That you're seeing these drilled reliably?
Yeah, so these will be our first 4-mile wells in the basin. But that said, SM to the north has drilled a few in deeper, longer total measured depth drilling environments. And also we've drilled some 15 kJ wells in the northern part of the basin where it's deeper. So from a total MD, when you consider kind of the turn leg as well as the return on that J, really we're talking very similar, total depths here. And, if you kind of look at the proliferation of 20K laterals in a lot of other basins, you've seen some wells in the Eagle Ford, that have been pushing 25, 26,000 feet laterals, and same in some of the Delaware and Midland basins. So, we feel confident that this is something we can do, and our drilling team's done a lot of modeling on, the viability, the torque and drag here. And, we feel like it's a very viable and doable operation.
Very good. Thank you.
Thank you.
Other questions, board? Yeah.
Yes, is the footprint of the well pad basically the same for a 20,000 foot well as the smaller or the shorter well?
Yeah, it's still the same surface hole. And so, yeah, I mean, the pad location will depend on how many wells are going in that pad. But I think that's, another advantage of the 20,000 foot laterals is you generally reduce the need to, have another surface pad at that 10,000 foot mark.
Okay, good. Any other questions, board? Okay, thank you, Mr. McDonald.
Yes, Mr. Chairman, that concludes our presentation in chief. At this time, I would move for admission of exhibits A through L inclusive.
Okay, admitted. Division?
Any objection?
No objection to that.
Okay. Okay.
With that, I'll just reserve closing remarks after the division makes its statement.
Okay. Division, over to you.
Yes, thank you, Mr. Chairman. About a week ago, the division filed a notice of non-opposition to this request. Following the testimony and exhibits presented by 4 Point, the division is satisfied and maintains its position of non-opposition. So should the board find that the petitioner's request does not negatively impact the correlative rights or result in waste, the division does not stand in the board's way in approving the request. Thank you.
Thank you. Okay, board, any questions in the division before we go back to Mr. McDonald? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. With that, again, we believe that the statutory and regulatory requirements for granting the request have been satisfied. It will allow for the greater recovery of resource without waste and with the protection of correlative rights. We would ask that you approve the request as submitted. We also thank you for your time and attention and consideration, and especially the accommodation to allow the witnesses to appear virtually. And we thank the IT department also for their cooperation in allowing that. Thank you.
Thank you. Okay, board, do we see a need to deliberate on this? I don't think there's any need to deliberate. I'll entertain a motion.
I move that we approve the request for agency action as submitted today.
Okay, any second? Motion's been made and seconded to approve the request for agency action. All those in favor say aye.
Aye.
Any opposed, say nay. Any abstain? Okay. Motion is unanimous, and Mr. McDonald, if you could please prepare the order.
Certainly will, and I'll submit it to council and to the board's counsel as well.
Okay, great, thank you.
Thank you.
Okay, so shall we just keep going on to number 5? Okay. Looks like we'll move on to agenda item number 5. So we'll wait for folks from Findlay to get set up.
So this is the one with that extra comment that I gave you to print it out.
Yeah.
Yep.
Mhm. Where did I do with that? Okay, looks like we're probably ready to go here. Agenda number 5 item is docket number 2026-038, cause number 47029, in the matter of the request for agency action of Findlay Resources Incorporated for an order modifying the board's order in cause number 470-20 to reconfigure certain drilling units established thereunder to accommodate longer lateral horizontal well development within sections 5 through 8 and 16 through 21, Township 2 South, Range 2 East, USM, and Section 9 and 16, Township 6 South, Range 19 East, SLM, all in Uintah County, Utah. Let's take appearances for council.
Fred McDonald of Counsel with Lear & Lear on behalf of the petitioner Finley Resources, Inc.
Okay.
Your mic's not on. Will you go ahead and push that button?
Okay.
Chris Eccles from Ray Faney and Hartle PLLC on behalf of Respondent Percussion Petroleum 3 LLC.
Okay.
Assistant Attorney General Gary White, here for the Division of Oil, Gas, and Mining. And seated to my left is Division Expert Peter Pankey.
Okay, thank you. Mr. McDonald, go ahead and proceed.
Thank you, Mr. Chairman. With me today testifying in person are Mr. Scott Pitzer, the Regional Land Manager. Gentlemen, would you stand up? Mr. Shay Atkins, who's the Executive Vice President, and Mr. Mark Wright, who's the Exploitation Manager of Finley Resources. I would ask that the Vice Chair swear them in at this time.
Go ahead, Mr.
Would you please raise your right arm to the square? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Okay. Go ahead, Mr. McDonald.
The resume of all three witnesses were collectively submitted as Exhibit A as supplement in this cause. Exhibit A in this cause. If asked, each will confirm the information reflected in their respective resumes is true and correct. Mr. Pitzer will be a fact witness only. Mr. Atkins has been previously recognized by the board as an expert in geology and horizontal well development on numerous occasions. Presuming there are no objections, I ask the board once again recognize him as an expert in those disciplines for purposes of this cause.
Division?
No objection. Thank you.
Board, any questions? Okay, go ahead, Mr. Oh, I'm sorry. Any objections? Okay, thank you.
Thank you. Mr. Wright will be appearing for the board for this first time, and so I will qualify him as an expert in petroleum engineering at the commencement of his testimony. And again, I will be moving for admission of our primary exhibits at the end of our presentation in chief, and to the extent required, the rebuttal exhibits at the end of our rebuttal presentation, if and as necessary.
Okay.
Members of the board, today Finley seeks amendment of the board's previous order entered in cause number 470-20 to shift the boundaries of two existing overlapping long lateral horizontal drilling units and the associated drilling unit boundary well units to facilitate the drilling of a longer lateral horizontal wells to produce from the Lower Green River Wasatch Formation. A true and correct copy of the 470-20 order was submitted as Exhibit B in this cause. In preparing for this hearing, I discovered a typo in the 470-20 hearing, which was carried through in the request for agency action. Specifically, drilling unit boundary well drilling unit number 4 identified in the 470-20 order incorrectly refers to Township 6 South, Range 21 East, when it should have been 6 South, 19 East. The context of the order makes it very clear that that was simply a typo, and the requested revision requested today, if approved, will remedy that error. The main reason that Finley has filed this request is the impact of the Uintah Special Meridian boundary, creating partial sections and the ability to drill an additional longer lateral wells, which is more economic and will better recover resource from those partial sections, in lieu of drilling shorter lateral wells as is currently required under the 470-20 order. Importantly, no change in setbacks have been requested, and consequently no adverse impact upon the correlative rights of the owners in the adjacent lands results. This is a crucial point of emphasis, as you will hear about more in this hearing. No other changes to the 470-20 order are being requested. The board has jurisdiction over this matter pursuant to Utah Code Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners in the requested drilling units and to the BLM, being the governmental agency having oil and gas jurisdiction over certain of the lands. The mailings were sent to these parties at the last addresses disclosed by the relevant BLM and Uintah County realty records. Finley was mistaken as to the oil and gas ownership in Subject 16, believing ownership was in fee. They instead are state-owned and administered by Sitla. The state lease was not recorded, and consequently the county search did not disclose its lessee. Because of those circumstances, there was no indication Sitla's records needed to be searched. Consequently, its oil and gas lessee did not receive notice. Notwithstanding, Sitla was mailed the request for agency action, and the lessee, as by its appearance today, nevertheless filed a timely response, as I will shortly outline, rendering the lack of notice moot. The record will also reflect notice was duly published in the Salt Lake Tribune on August 2nd, and the Uintah Basin Standard and the Vernal Express on August 5th. On August 10th, the division filed a response indicating its non-opposition to the granting of Finley's request, presuming Finley satisfies its burden of proof, which we will do today. On August 4th, Aaron Giving and Sharon Ngono, record oil and gas owners in adjacent lands, not the lands at issue, filed responses. They objected to the request, but neither provide an explanation for their objection nor any supporting exhibits. As Mr. Pitzer will confirm, Finley then attempted to contact them by phone and email to identify the nature of their objections and attempt to resolve them, but never received a response. However, they are not present here today, and consequently, pursuant to Rule 641-108-400, I ask the board to overrule their objections. Additionally, on August 10th, Percussion Petroleum 3, LLC, filed an objection to the request with no supporting technical exhibits. It initially complained it was not notified of the request. However, as Mr. Pitzer will confirm, there was nothing in the BLM or county records reflecting Percussion as the owner of the BLM lease covering subject section 9. And as I previously addressed, the fact that Percussion timely filed a response renders the lack of service upon it moot. Finally, Finley was under no obligation to review the records pertaining to sections 4 and 5 of Township 6 South, Range 19 East, as the owners in those sections are not parties whose interests are legally affected by the request, since there is no change in the setbacks established under the 470-20 order. Importantly, be aware these particular lands are the asserted crux of Percussion's objections. Specifically, Percussion claims sections 4 and 5 should be included in one of the revised drilling units in order to promote greater resource recovery, prevent waste, and protect its correlative rights. It is important to emphasize it does not complain about its correlative rights and the subject lands are being adversely affected. However, the board has already determined and ruled in the 470-20 order that the 330-foot setback from these lands adequately protects the correlative rights of owners in those adjacent lands, and Percussion has filed no technical exhibits to suggest otherwise. Furthermore, there is nothing to show why Percussion cannot independently develop the resources on its leases in those lands. It could drill vertical, short lateral, J or U wells, or form a drilling unit inclusive of those lands and the lands to the north for longer lateral horizontal development. Furthermore, Finley is under no obligation to drill wells for the benefit of Percussion as to its Section 4 and 5 lands. In fact, to do so would first increase Percussion's share of production without taking any development action on its own, essentially riding Finley's coattails. And secondly, it would instead dilute the production allocation to Finley's lessors in the subject lands and consequently adversely affect their correlative rights. Finley does have a legal duty to protect its lessors. Finally, as a procedural note, the board cannot today amend the request to include Section 4 and 5 as requested by Percussion because the production interest owners within the subject lands have not received any notice that that action would be taken. A separate request would have to be filed to which Finley will strongly object based on the foregoing. For these reasons, Finley believes Percussion simply is not an interested party to this case whose legally protected interests are adversely affected, and the board should likewise overrule its objection. No other objections or responses are received, and no other party has made an appearance here today. With that, I'll commence my examination of Mr. Pitzer. Let me turn that on. Mr. Pitzer, please state your name and business address for the record.
Scott Pitzer with Finley Resources and P.O. Box 2200, Fort Worth, Texas 76113.
And what's your current position with Finley and how does it relate to this request?
I'm the regional land manager assisting with land-related issues pertaining to the lands at issue in this cause.
All right. For the record, please state the corporate and bonding status of Finley.
Finley is a Texas corporation with its principal place of business in Fort Worth, Texas. It is duly qualified to conduct business in Utah and is fully bonded with all relevant federal and state of Utah agencies.
And I'm going to show you what have been marked as Exhibits C through F, substitute Exhibit G, and Exhibit H. Do you recognize these exhibits?
Yes.
Were they prepared by you or Finley personnel with your review and input?
Yes, that's correct.
Turning your attention to Exhibit C, would you please explain what it shows?
Yes, this is kind of a locator map. It shows the subject lands are in Uintah County, approximately 2.5 miles northeast of Fort Duchesne, and the lands are bisected by US 40.
Now turning your attention to Exhibit D, would you please explain what this shows?
This shows the lands in which we are here talking about today.
And this reflects the requested drilling units as opposed to the existing ones?
That's right. This is the requested drilling units.
All right. Now, in that regard, turning your attention to Exhibit E, please explain what this shows and its significance to the board.
So this plat is comparing the current 470-20 DSUs with the requested revised DSUs. As you can see, it moves sections 5 and 8 of 2 south, 2 east from the DSU with sections 6 and 7 previously established under the 470-20 order to the revised DSU with sections 5, 8, 16, 17, 20, and 21 of 2 south, 2 east, and sections 9 and 16 of 6 south, 19 east, previously established under the 470-20 order. Also, this changes the drilling unit boundary well DSU along the eastern boundary of sections 18 and 19 DSU and the section 16 et al. DSU, established under the 470-20 order, to additionally add sections 5 and 8. In other words, we're revising the drilling unit boundary well DSU along the common boundary of the 3 revised long lateral horizontal well DSUs.
Now turning your attention to Exhibit F, please explain what this shows.
This is showing the mineral ownership, which is mainly fee, some federal and some state. And in section 16 is where we previously showed that it was fee, although it is state-owned minerals. Findlay remains the controlling working interest owner through designation as operator in all of the subject lands as the board found in the 470-20 order. As previously mentioned, Aaron, Gevin, and Sharon Ngono are mineral owners in sections 4 and 10 of 6 South, 19 East, not the subject lands. They were erroneously identified in the record search as owning an interest in the subject lands. After receiving their objections, I attempted to call and email them to determine the nature of their objections and to try and resolve them, but I never received a response. As to Percussion's claim arising under the federal lease covering parts of sections 4, 5, and also subject section 6 of 6 South, 19 East, the search of the BLM records disclosed Robert L. Bayless, producer, LLC, was the lessee, that the lease had been terminated for failure to timely pay a rental, and that a petition for a Class 2 reinstatement has been filed, but a reinstatement decision is still pending.
All right, just for clarification, I believe you said section 6. You meant section 9 of Township 6 South, Range 19?
Yes. Yeah.
Right. Now turning your attention to substitute Exhibit G, would you please explain what this shows?
This shows the existing wells. All the vertical existing DSUs that are at issue are overlapping, so no impact on existing production allocation. No wells that are authorized under the 470-20 order have yet been drilled on the subject lands, but there are 12 approved long lateral horizontal APDs on the adjacent lands to the south.
All right, finally, turning your attention to Exhibit H, and I'm also going to turn your attention to the Certificate of Service and the Supplemental Certificate of Service. These were pleadings that were prepared by my office and are on file with this matter already. Do you recognize the names and addresses of the parties shown?
I do.
And who are those parties and how are those names and addresses determined?
These are all of the parties that that have an interest in the subject lands, and the addresses are compiled through Findlay's internal records, including title opinions and searches of the BLM and Uintah County records, all prior to the filing of the RAA by Findlay's contracted land service company or companies.
All right, and on that list are included the school and institutional trust lands and the Robert L. Bayless producer, is that correct?
That's correct.
But it does not include Percussion. Can you please explain why?
Yes, Percussion was not notified because of we didn't realize that they owned the state lease in section 16 because it was not filed of record.
All right. With that, Mr. Chairman, that concludes my examination of Mr. Pitzer. However, I'm going to reserve the right to recall him as a rebuttal witness if and as necessary.
Sure. Okay. So we go with the question first, the division. Okay. Division? Any questions?
Chairman Walker, if you would indulge me, I would prefer that percussion have an opportunity first.
Okay. Let's go to percussion. Mr. Eccles?
Yeah, I don't think we have any questions for this witness. Thank you.
Okay. Division?
Then I'm in the same camp. Thank you.
Okay. All right. Thank you. Go ahead, Mr. Pitzer. Go ahead, Mr. McDonald.
With that, I'll commence my examination of Mr. Atkins. Mr. Atkins, would you please state your business address and name and address for the record?
Sure. Thank you for having me. My name is Shay Atkins. Business address is P.O. Box 2200, Fort Worth, Texas 76113.
And what's your current position with Finley, and how does it relate to these lands at issue today?
Yeah, my current position is Executive Vice President, overseeing the geology and development of of the lands at issue.
All right, turning your attention now to Exhibit I. Was this prepared by you or Finley personnel with your review and input?
Yes, it was.
Okay, would you please explain to the board what it shows and its significance to today's hearing?
Yeah, Exhibit I is a north-south cross-section spanning from south to north across the application lands. The intent of the cross-section is to show the uniformity through the Lower Green River and Wasatch formations, extending across the application lands, but also on the far right side of the cross-section, also to the lands north of our proposed area today.
All right, and based on this exhibit, is it your expert opinion that the continuity and uniformity justifies drilling a longer lateral horizontal well and would result in additional resource recovery of sections 5 and 8?
Yes, it does.
All right. Would you confirm for the board that you had the opportunity to review the geologic exhibits filed in cause number 470-20 and the geologic findings of fact of the board in the order?
Yes.
All right, and is it your testimony that you don't see any material changes to those exhibits or the testimony relating to that?
Yes, that's correct.
And that includes the geologic continuity and the ability to drill 2-mile or longer lateral horizontal wells?
Yes, sir.
All right. Can you explain, since it's also your obligation to talk about the development plan for Finley, kind of address why Finley desires to drill over in this area and what its plans are?
Yeah, I mean, this area in general represents pushing of long lateral horizontals to the north and to the east of where existing production currently is. The request for the ability to drill longer than 2-mile laterals in this area increases our recovery of the lands that we operate. It also represents a 13 to 15, roughly 15-mile step out of those extra long laterals. And so Finley is prudently developing the acreage that we operate, trying to maximize the recovery of those lands while also pushing the technology and the drilling technology further to the north and to the east in the Uintah Basin.
But at this point, you're only seeking 2-mile or a little bit longer to cover 5 and 8 as opposed to a 15,000 or a 20,000 or a 25,000 foot well in this area.
That is correct.
And that's due to the fact that this is the furthest east that you've seen those type of wells, and you're almost 15 miles away from the western development.
Correct.
Okay. With that, Mr. Chairman, that concludes my examination of Mr. Atkins.
Okay. Mr. Eccles, any questions for this witness?
No, Mr. Chair.
Okay. Division, any questions for this witness?
No, Chairman, thank you.
Okay. Board, any questions for Mr. Atkins? Okay, seeing none, thank you, Mr. McDonald. Go ahead.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Wright.
Okay.
Mr. Wright, please state your name and business address for the record.
Excuse me, Mark Wright, Finley Resources, P.O. Box 2200, Fort Worth, Texas 76113.
And what's your current position with Finley? How does it relate to these lands at issue today?
Exploitation manager over the areas that we're discussing.
All right, since this is your first time before the board, although the board has its your resume in front of them, would you just give a brief outline of your education, work experience, particularly experience with horizontal well development and unconventional plays and basins analogous to the Uintah Basin, any certifications, license, publications, etc.?
Sure. I graduated from Texas Tech University December '95 with a bachelor in petroleum engineering. Went to work for Anadarko right out of college. Worked drilling, completions, production reservoir with them in Southwest Kansas, East Texas, North Louisiana, and brief stint up in Canada. Went to work for XTO Energy after that, working strictly on the reservoir side, working East Texas and North Louisiana, drilling vertical Travis Peak wells and horizontal Haynesville wells. From there, went to a startup, Veritas Energy. We drilled horizontal wells in the Fort Worth Basin and in central Oklahoma. Let's see, from there, Morningstar Partners, operations, drilling, production, completions in West Texas. And then was VP of operations with Founders Oil and Gas, working West Texas as well. We drilled 30 wells out there on a property we bought from ConocoPhillips. And then last 3 years, I've been with Finley Resources, working Uintah Basin and Wyoming.
Based on that testimony and his resume, I would ask that the board recognize Mr. Wright as a expert in petroleum engineering for purposes of this cause.
Okay, Mr. Eccles, any objections?
None, Mr. Chairman.
Mr. White?
No objection.
Board, any questions of this witness? Okay, we're good.
Accepted then?
Yes.
Thank you. Mr. Wright, I'm going to show you now what has been marked as Exhibit J. This is a 2-page exhibit. Do you recognize these exhibit?
Yes.
And was it prepared by you or Finley personnel with your review and input?
Yes.
Right, would you please turn your attention to J1, please explain what it shows?
That is a survey survey plat reflecting the layout of longer laterals on the revised DSUs.
Showing how you would go through sections 5 and 8, is that correct?
Yes.
Right, and then turning your attention to Exhibit J2, please explain what this shows and its significance.
Yeah, this is showing with the existing units there in section, was it 8?
5 and 8?
Yes. The laterals would be shorter, maximum of basically a mile, and the rate of return on those is in the low 20% range, which is for the risk that you'd be taking wouldn't be worth drilling. And the ones that are shorter, half mile or less, just they're uneconomic due to the lateral length. The other exhibits showing the longer laterals, those are the 100% rate of return range. So from an economic standpoint, it definitely benefits us to drill the longer laterals.
Okay, and you heard Mr. Atkins' testimony regarding the development plan. Could you kind of elaborate on that a little bit as well?
Yes, the plan here would be with the revised units in the southeastern unit to drill the 2 mile to 2.5 up to 3 mile laterals.
And again, this is pushing out almost 15 miles, 15 miles west of where the 3 mile or 4 mile development is occurring.
Yes, the closest ones that I found looking at drilling info via Inveris were 13 to 15 miles to the west of us.
Right, and so the intent here is to continue to develop and test 2 miles, or in this case, just a little bit longer because of the circumstances involving sections 5 and 8?
Yes.
Right. So your expert opinion then, the revision to the requested drilling units will allow the greater development of sections 5 and 8, both from a resource recovery and economic standpoint without committing waste?
Yes.
All right. Could you confirm for the board that you have reviewed the engineering exhibits filed in 47020 and the engineering findings of fact with the board with respect to that contained in its order?
Yes.
And is there any material change required from the testimony and findings that the board had regarding particularly the setbacks?
No.
All right. So it's still valid at this point?
Yes.
All right. With that, Mr. Chairman, that concludes my primary examination of Mr. Wright, but I will reserve the right to call him as a rebuttal witness as necessary.
Thank you. Mr. Eccles, any questions?
Yes, Mr. Chairman. Looking at the right-hand side of this Exhibit J2, isn't it true that the longest of these longer lateral wells, the ones that go into Section 5, those are approaching 3 miles in length? Is that correct?
Yes.
Okay, thank you. That's it.
Okay. Mr. White, any questions of this
Nothing
witness?
Nothing right now. Thank you.
Okay, board, do I have any questions of this witness? Seeing none, go ahead, wrap up, Mr.
Thank you, Mr. Chairman. This concludes our primary presentation in chief. At this time, I would move for admission of Exhibits A through F, substitute Exhibit G, and Exhibits H through J inclusive.
Okay.
Any
Amended?
objections?
Any objections, sir? Mr. Eccles?
None.
No objection.
Okay, good.
Accepted then, thank you. I'm also going to request the board to take administrative notice pursuant to Utah Code Section 63G-4-206, subparagraph 1B, Roman 4, of the geologic and engineering exhibits and testimony relating thereto accepted into evidence in the 47020 hearing, as referenced in Mr. Atkins and Mr. Wright's testimony today. I do have certain of those exhibits which may be offered as rebuttal exhibits if necessary, depending on Percussion's presentation. I'd like to confirm if the board will accept that administrative notice.
Yes.
All right, thank you.
Accepted.
All right, with that, that concludes our presentation at this time.
Thank you. Okay, Mr. Eccles.
Thank you, Mr. Chairman and members of the board. I'm joined today by 2 witnesses. For land, we have Mr. Adam Presnall, Vice President of Land at Percussion Petroleum 3, LLC. And for geology and geotechnical matters, we have Mr. Riley Brinkerhoff, founder and partner at Hive Partners. I would ask that the Vice Chair swear them in at this time.
Okay.
Yes, please raise your right arms to the square. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Thank you, Mr. Vice Chair. The resumes for these witnesses were filed as Exhibits K and L, respectively, and if asked, both would verify that the contents of their resumes are true and correct. I'd like to thank the board for granting leave to belatedly file those exhibits, by the way, and I've provided hard copies if anyone has not yet had the opportunity to review them. For purposes of this hearing, I will not be seeking to qualify Mr. Presnall as an expert witness, but I will be seeking to qualify Mr. Brinkerhoff as an expert. So we'll begin with Mr. Presnall. Please state your full name, your employer, and your position with that employer and business address for the record.
Sure. My name is Adam Presnall. I'm the Vice President of Land for Percussion Petroleum 3, LLC, located in Houston, Texas, 1001 Fannin Street, Suite 1275.
Thank you. And now, please allow me to draw your attention to Exhibit E, PERC. Would you briefly explain the nature of Percussion's objection to the RAA using this exhibit to illustrate Percussion's objection?
Sure. The exhibit is based on Petitioner's Exhibit E, which we saw previously. As with Exhibit E, on the left side of the exhibit, you see the current DSUs under the existing order. On the right of the exhibit, we show what the modified DSUs would look like if Sections 4 and 5 of 6 South 19 East are included in those easternmost unit in that modified DSU. We do hold leasehold rights in both of those sections, in 4 and 5. And to point out, essentially we agree with the rationale Finley has provided for their requested modified DSUs, but we believe that the same rationale being brought forward should include sections 4 and 5.
And just as a shorthand for this hearing, we may refer collectively to those sections 4 and 5, 6 South 19 East SLM as the percussion sections. Now I'd like to draw your attention to Exhibit F PERC. Would you please explain what this exhibit shows?
Sure. It's based on the Petitioner's Exhibit F, which was captioned Mineral Ownership Map. In our version, we've just shown the mineral ownership if we included sections 4 and 5. You can see it's mostly fee with some fed with some fed acreage.
And how much of that does percussion hold leases on?
So we have fee leases covering 41 acres in Section 4, and we've got, let's see, we're in the process of acquiring, as the petitioners mentioned, we have an agreement in place to acquire federal acreage from Robert Bayless Company. So we have roughly 174 net acres in 170 in Section 4, and a little more than 3 net acres in Section 5.
And you mentioned that you're in the process of acquiring the federal lease. Could you elaborate on that?
Yeah, I mean, we have an agreement in place with the Bayless Company, and they're working things through with the BLM at the moment.
Okay, and in the prior examination, Mr. McDonald noted that the federal lease is in the, there's an application to reinstate that lease. Is that correct?
That is correct.
Okay. I'd now like to draw your attention to Exhibit M. Please briefly describe what this exhibit shows.
Yeah, so in this exhibit, we've taken what Finley has provided on the right half of their Exhibit J2, moved it to the left side of our exhibit. The diagram reflects the proposed long lateral horizontal wells. Finley anticipates drilling in their requested modified DSU, but this only shows those 6 long lateral horizontal wells located roughly, or mostly in the western half of those sections of their modified DSUs. That would leave the eastern half of this modified requested DSU undeveloped. On the right-hand side of the exhibit, we've shown that if percussion sections are included in the modified DSU, the entire DSU can be efficiently developed using long horizontal wells with roughly 2 to 3 mile laterals. This includes not just the additional acreage with percussion, but the original interest from the proposed DSU.
And from a land perspective, why is the modification requested in Finley's RAA necessary?
Yeah, so like we've said, we're not opposed to their application. It's just we have that Uintah special meridian boundary to the southwest, the Salt Lake Meridian to the northeast. That boundary creates irregular sections, and sometimes, like in the case of Section 5, they're very small. So what Finley's application seeks to do is reshape the current DSUs, as I understand, is to maximize the efficiency with which the oil and gas under these lands may be developed using the longer than usual laterals.
And what's the difference in acreage between Percussion's preferred version of this DSU and the version that Finley's requested?
Yes, so on Finley's Exhibit E, they show 2,099 acres. Our Exhibit E-Perk, if you include Sections 4 and 5, it's going to take us to approximately 2,566 acres, so a difference of approximately 467 acres.
And if Finley gets the modified DSUs it's requesting and develops them according to the plan laid out in the RAA and the petitioner's exhibits, what are the implications for the development prospects of the percussion sections?
Yeah, so generally speaking, you look at development as in rectangles, and it seems to be the more efficient way to develop these resources. If we look back at, you can look at this exhibit. If you look at the 2 sections to the north, they don't line up with Section 4. I mean, there's a clean break there. It would make it a little more difficult to put those applications together and see how you're going to develop Section 4 and 5 with 33 or 34. So, it definitely makes it a little more difficult to put together these units, probably creating another issue when you head north.
So,
and you're not, and to add, we're not going to go east-west here. Mr. Bickerhoff will show that, this isn't a east-west development. So to combine it with Sections 4 and 3, or 4, 5, and 3, and 2, wouldn't make reasonable sense either.
Okay, so to summarize, if the percussion sections are not included in the modified DSU, will that increase the likelihood that the mineral resources underlying these lands would not get developed?
I believe it would make it more difficult, correct.
Relative to the modifications Finley's requesting, as reflected in their filings and exhibits, would including the percussion sections increase impacts?
Based on the exhibits we've seen, it looks like they'll be drilling wells from the south to north, so the surface impact would be minimal. So really, we don't see any major issue there.
And were exhibits E perk, F perk, and M prepared by you or under your supervision, direction, and control?
They were under my supervision, direction, and control, yes.
Do you believe that the relief sought today by percussion, namely the inclusion of the percussion sections in the modified DSU, would maximize recovery, minimize impacts, prevent waste, and protect correlative rights?
I do.
Do you believe the relief sought today by percussion better furthers those objectives than does the relief sought today by Finley?
I do, and to clarify, we fundamentally agree with Finley's rationale on what they're trying to do here. We just believe that if you apply the same rationale to the amendment to 5 and 8, you should apply that same rationale to Section 4.
That concludes my examination of this witness. Any questions from the board or other?
Mr. McDonald? Well, I'll go to McDonald.
Yeah, I have some cross-examination questions. Mr. Presnell, do you admit that the BLM records still reflect Bayless as the record owner of the federal lease, and that the reinstatement is still pending, that the lease was terminated and the reinstatement is still pending?
That is correct.
So there was no notification in the BLM public records that percussion had any interest in that?
Correct, and I don't think we've opposed the notification. We're good there.
Okay. Has the state lease on Section 16 been issued?
Yes, sir. It was issued back in, I want to say, March.
Do you acknowledge, though, that the SITLA public records do not show the lease?
I guess I'm not as familiar with researching the SITLA records. I do know that when we were notified, it was published on their website that we were the winner along with all the other bidding parties.
But the lease has been physically signed and issued?
Yes, sir.
Okay. All right, but it's not recorded?
No, sir.
All right, thank you. Is percussion in a position to drill and operate wells?
Sure, yeah.
So it does operate wells and drills wells?
We are in our third iteration. We've drilled several wells through Percussion 1 and Percussion 2 across the United States. We've entered into several contracts. Our plan is to continue to operate wells in this area. And again, we're not objecting to Finley drilling these wells. We're excited to see the development push west.
But you're capable of drilling your own wells, correct? I mean, you have the
correct
technology and ability.
We do, yes, sir.
All right. Have you filed any APDs?
We have not.
For this area?
We have not.
All right. So there hasn't been any filed for Sections 4 and 5, correct?
We have no, not by us.
All right. Do you know who owns the working interest in Sections 33 and 34 of 5 South, 19 East?
I don't have it on me. I know we've done title work out there, but I don't have it on me.
Have you even approached them, the owners of the working interest owners, to possibly talk about drilling longer horizontal wells up into those sections?
We've talked to several parties in this area. To recollect if we've talked with those particular owners, I'd have to go back and look at my records. Happy to get back and let.
But there's no reason why you couldn't form a drilling unit with those parties if they were agreeable?
Correct.
Okay. If you give me a second, let me just. Have you heard of J and U wells?
We have heard of J and U wells, correct.
All right, and is that something that percussion could drill, has the opportunity to drill or would consider drilling?
I think we would follow the same logic of why you're amending Sections 5 and 8 to this unit. It's the economic state that 10,000 to 15,000 foot laterals and longer, just as in the case we heard earlier today, just makes more sense for.
But a U well would still be 20,000, right?
U well. Sure. I guess however I'm not an engineer and won't testify to how.
Okay,
how
but
long
it's a possibility of it to drill and develop your acreage, isn't it?
in section 4?
Section 4 or 5, and if you form a drilling unit with 33 or 34, you could even do it that way.
I don't think you can get, I mean, we just have rights in section 4, so I don't know why we're talking about 33 and 34, but for section 4 to develop by itself, I don't think you're getting, I mean, just looking at the map, it's not a standard 640. I don't think you're going to get a 10,000 foot U lateral in there.
Well, it's possible with it, isn't it?
Well, I'm not an expert
An
in
engineer,
that side,
okay,
Mr.
just
McDonald.
asking, okay. All right, with that concludes my cross.
Okay. Mr. White, any questions of this witness?
Give me just a second, Chairman. Thank you. Sir, Gary White with the Attorney General's Office. I represent the division.
Pleasure.
Have the owners in Section 4 been given notice of your objection?
I do not believe so. No.
Is it your position that they don't require notice for the modifications you're requesting today?
I'm unfamiliar with that side. Apologize.
Okay, thank you. And this might be a question for Percussion's other witness, and if that's the case, that's fine. We heard Mr. McDonald state in his opening statement that it would affect Finley's correlative rights if your request today were granted. Can you comment on that? Do you have a position on that?
Sorry, could you say that again? Just one more time.
I thought I heard Mr. McDonald state in his opening statement that it would affect Finley's correlative rights if Percussion's objection essentially were granted today, that Section 4 were included in the unit. Do you have an opinion on that or a position?
No, I don't.
Okay, thank you.
Board, do you have any questions of Mr. Presnell?
I was just wondering, who the other owners in Section 4 are. It's not Finley then.
No, Finley is not. According to our records, Finley is not in Section 4 or 5.
And so you're requesting an addition here, which represents about half. You're about a half interest.
That's
half
correct.
The interest in
Yes, sir.
Section 4.
Yes, sir. And we know there are unleased fee owners. We have the BLM lease, and we've discussed that at length today. And then we have the fee ownership that still exists. And yeah.
Okay. Yeah, and I don't know if any of you are ready to. It would be helpful to see a bigger picture of the whole area and how things are all fitting together. You know, going north-south, mostly north-south, because these are going to be stand-up wells. Can you help me in any way with that? Like, you know, like Mr. McDonald's saying, you know, you could go north with your northern owners. What is the? Yeah, it's just an awkward angle there. I don't know if you planned that.
Yeah, so we've seen spacing out there. I don't have a map off the top of my head of how the units looked, but it seems, based on what we've seen in the basin, it's going towards rectangle 10,000 foot. And when you take it to the north, you can see how 4 being excluded and being taken to the north kind of creates another situation where we're going to divide 4 in half. I don't know how the commission feels about this. I apologize. This is my first hearing. Was hoping it would be a little bit different. But you know, so still understanding the rules and working with, you know, many of the attorneys in this room, understanding how we put together these units. But it's 2 and 3 mile laterals. 1 mile is just destroys economics today.
Yeah. So is now the appropriate time to ask your witness a question also? It's not.
We're still his.
Okay.
We go finish up.
All right.
And then go to.
But if it's helpful, not understanding the procedure, happy to follow up showing the existing units based in this general area, maybe a zoom out of a couple townships, and we'd be happy to submit that.
Okay.
This is a question for Mr. McDonald. I believe the public notification of SITLA leases, the official place is with SITLA, and they do not have to be recorded with the county. Is that your understanding?
That would be the case again, but if you search the SITLA records and all it shows is that they're SITLA lands as opposed to a lease that's been issued, that would be a question. But again, that's Section 16, and Section 16 is within this area anyways. And they're not complaining about Section 16. They're complaining about Sections 4 and 5.
Okay, as long as we're clear that they don't have to be recorded in the county.
Yes, but again, the indication was in the county records that there was no valid lease covering those lands. SITLA was notified based on the fact 16. That it was no one, yes.
Okay.
Okay, any other questions of this witness? Okay, let's move on, Mr. Eccles.
Thank you. If I may briefly respond to the question about notice to owners in Section 4, I believe Mr. McDonald is correct that if the board feels that, percussion's argument makes sense, that Sections 4 and 5 ought to be considered for inclusion in a modified DSU, that we would need to do another RAA, and that would be addressed in the notice, process for that RAA. Thank you for your testimony. At this point, I'd like to bring up Mr. Brinkerhoff.
If it would help expedite things, we'll stipulate that Mr. Brinkerhoff can be recognized as an expert in geology. I've done it several times.
Okay.
So
we appreciate that.
Division, you got any problems with Mr. Brinkerhoff?
I got lots of problems.
Oh, I mean, other than he owes you money, but yeah.
Get out the box. Yeah.
Okay.
No objections, thank you.
Okay, Board A, questions about Mr. Brinkerhoff's expertise? Okay, go ahead.
Thank you. Mr. Brinkerhoff, could you please state your name, title, and employer for the record?
Riley Brinkerhoff, partner and chief operating officer of Hive Partners. I'm acting in this capacity as a consultant for percussion, and my address would be 833 North, 1200 East, Provo, Utah.
Thank you. Now, Mr. Brinkerhoff, I'd like to first draw your attention to Petitioner's Substitute Exhibit G. Now, what do you observe about the long lateral horizontal wells depicted in this exhibit?
They run north-south. They run north-south.
And in your expert opinion, why is that?
Mr. Brinkerhoff, you can just let it stay on the green. You don't need to push the button. That's okay.
I've done this before.
You're good. Thank you.
They run north-south because of the maximum horizontal stress in this area that basically runs east-west by northwest by southeast. And so they run north-south to have the best fracture propagation and best recovery from the reservoir.
So, in your expert opinion, how would you characterize the likelihood that percussion sections could realistically be spaced with lands lying to the east in Section 3, or possibly further east, and developed via laydown long lateral horizontal wells?
Yeah, that would result in waste. Laydowns would not be effective in this area.
We've had questions about whether, if you put these lands with lands lying to the north, 33 and 34, whether you could, economically develop them this way. Do you think, in your opinion, that it would make sense to develop?
It would not. In this case, you would end up with stranded or either partial sections in the DSU, which we have not done in the Uintah Basin. We have kept them to section boundaries, and where they have the step at the township boundary would result in waste.
Now I'd like to direct your attention to exhibits J1 and J2, which kind of go together. So looking first here at exhibit J1, in this exhibit, Finley argues that modifying the DSU boundary would allow long lateral horizontal wells to be drilled in sections 5, 8, 17, and 20, while also preventing waste and additional surface disturbance and protecting correlative rights. So preventing waste, protecting correlative rights, along with maximizing resource recovery and minimizing impacts. These echo the goals that I was questioning Mr. Presnell about a few minutes ago. Please keep these goals in mind as we now look at Exhibit J2. Given those goals we were just discussing, maximizing recovery, minimizing impacts, preventing waste, and protecting correlative rights, do you agree that the plan of development depicted on the right-hand side of Exhibit J2 better furthers those goals than the one on the left side?
Yes, correct.
And now turning to Exhibit M, which we've seen previously, keeping in mind those goals we're just discussing, between the plans of development depicted on the left-hand side and the right-hand side of this exhibit, in your opinion, which would best further those goals?
The right-hand side.
How so?
You're able to maintain those longer laterals. You don't have to have anything complicated like J or U wells. We don't have any J or U wells in the Uintah Basin or in Utah. And 4 is going north-south is not even a full mile anyway. So you just get more efficient development of the area.
Thank you. That concludes my examination of this witness, Mr. Chairman.
Okay, I'm sorry.
I would move that we admit exhibits E perk, F perk, and M, along with the resumes K and L at this time.
So admitted. Mr. McDonald?
Thank you, Mr. Brinkerhoff. Just a couple questions on the stress. The stress orientation, isn't it simply to determine where you should where directional that you should drill?
Correct. They'd be standards.
And it also relates somewhat to the drainage depending on the angle of the stress, correct? So that you can perpendicularly do that.
Correct.
Well, doesn't a short lateral horizontal well or a U well that's drilled in a north-south direction also provide that same perpendicular intersection that would maximize the recovery?
So a short lateral north-south one still would have that same optimal orientation. It would just be less economically efficient because it'd be short.
Well, if you drill to the north then and go up into section 33 or 34, wouldn't that then also be a little bit more economic then?
It would. The issue would be the offset at the township boundary, leaving stranded acres.
If you look at Exhibit M on the left, that's the existing spacing. And it's done there where partial sections are included, are they not?
They are.
Okay. So it is a possibility to be able to do that for 33, possibly portions of 34 even.
Yeah, no one would claim that it's not impossible. We'd just say it's less efficient.
How is it less efficient if everybody agrees to it?
You would be able to block it up much easier with adding section 4 and 5 to the requested DSU than trying to come up with some difficult partial sections with 33, 34, which we haven't done in the Uintah Basin in general.
Well, but it's done along the Uintah Special Meridian. I mean, it's in the 470 order.
Yeah, we were forced to by the nature of the meridian.
That's what I'm saying. So it is a possibility to create drilling units if you agree with those parties up there to drill in a north-south and in a longer lateral situation, perhaps a 10K.
Yes, it's definitely possible.
All right, thank you. That concludes my cross.
Okay. Division, any questions?
Chairman Walker, I've just been informed that the YouTube stream died. I don't know if that's...
It should be back online. We had to reset, and it should be back online now.
Okay.
Okay.
Just a few questions for you, Mr. Brinkerhoff. First of all, my very poorly worded question for the prior witness. Can you comment on correlative rights to Finley if Percussion's proposal is accepted?
I don't have, not being a landman, being a simple geologist, correlative rights would be beyond my level of expertise.
Okay, thank you. You said a UL would be less economically efficient. Can you explain why?
Yeah, so ULs, just for everybody to be familiar, you're going to drilling down to get to some boundary where you're getting within the required setback of the DSU. You're then going to directionally force that well to come around 180 degrees and drill back. They're being done, but they haven't been done in Utah, and they are relatively risky as compared to just a straight lateral where you're not trying to do that additional directional work. Remember that after you get that directional work done, assuming you are successful, it's going to take more time drilling, and you're going to have to get casing down through that, all of which adds dollars and risk to your wellbore.
That's it. Thank you.
Okay, board, do we have any questions of Mr. Brinkoff?
So if you were to do your own DSU and leave as requested here, so Finley, assuming Finley's request is approved, so you have a pretty sharp angle there, and your setbacks are going to be at an angle. What complication does that add to your drilling?
So say you tried to do it with 33, you'd either have short laterals going down, drilling south from 33 and getting part of 4. Either way, you're having less ideal lateral length. By the time you got to the east side of 33 and down to, you know, have 1 or 2 wells that would be full length. But with that angle, it would definitely leave either difficult, more expensive resource or stranded resource.
Mm-hmm.
More likely, you would not get the third of a section in 33. Just they're too short to drill.
Thank you.
Board, any other questions of Mr. Brinkerhoff? Oh, go ahead, sorry.
Who owns the rest of the interest in Section 9 that's within this proposal? Do you guys own it 100%? Does Finley own it 100%?
I don't know the answer to that question.
Do you think it's fee?
I think part of it is fee.
Okay, thank you.
Okay, Mr. Eccles, anything else?
No, Mr. Chairman, that concludes our case.
Okay, thank you.
We'd like to thank you and the board.
Okay, thank you. Okay, let's go ahead and hear closing arguments from.
Well, would like to call rebuttal witnesses.
Oh, sorry. Okay, thank you.
No worries.
Go ahead.
I'm going to recall Mr. Pitzer first. The board should have received a packet of 6 rebuttal exhibits. I'm going to refer to just one of them right now.
Did we?
Rebuttal Exhibit 2. I'll remind, first of all, Mr. Pitzer, you're under oath. Turning your attention to Rebuttal Exhibit 2. If you give me a second here.
Did we get to see these exhibits? I have not seen these.
Mr. White, have you seen these?
Here they come.
I have not seen them either. I
will represent that this is a true and correct copy of a letter of support that was submitted by Robert L. Bayless in the 47020 order, and it shows that the board stamps on it. I'm sorry, I handed them out this morning, and they should be delivered to you now. If there's any objection to it, let me know. But this is an existing record from the board's records in 47020. Yeah, why don't you we'll take one too, just so you can have it in front of you. Thank you.
This is 2025.
Mr. Pitzer, do you recall discussions in the 47020 order with Robert L. Bayless regarding the requested drilling units at that time?
Yes.
All right. Did Bayless express any concern over the correlative rights that they had in sections 4 or 5?
No, they did not.
And that's reflected in this letter, that it's a letter of support for the request that was made for those drilling units?
That's right.
All right. That concludes my rebuttal examination of Mr. Pitzer. And I would, well, no, and I'll finish up later with after I've done with the other rebuttal witnesses.
I'd go ahead and ask him.
Okay, so Was there a rebuttal exhibit 1?
There was, but I'm not going to do it because Percussion has already acknowledged that Bayless is shown as the record title owner of the federal lease covering
Okay.
Section 5 and 9.
All right. And it's my understanding that
If they have any
you guys
cross
have
for
both
him on the
received these.
rebuttal.
Just a second.
Yeah.
It's my understanding, Mr. Eccles and Mr. White, that you're seeing this for the first time here,
Correct.
as are we. Okay.
That's correct. If I could just have a chance to read it.
Yeah.
I also note this letter is dated almost a year ago. Is there,
That was in the 47020 hearing, which was held a year ago.
gotcha, thank you.
So was there a letter in support for this application?
No, but there was no filing made by Bayless at all.
Okay, so I'll just ask them for, if they want to respond or anything. Okay. Okay, Mr. Eccles, any kind of response to this exhibit?
Other than my previous question about whether there'd been a more recent letter in support for this particular RAA, no.
Okay. Mr. White, any response on this?
Mr. Pankey has a question
Okay.
that he can better articulate than me.
Who's he going to ask? You have a question, or?
I guess I'll do it, Al, Chairman Walker. Peter Pankey with the division. I just wanted to, just one second, I got to talk to.
This is turning out to be kind of messy.
Yeah, that's okay.
We'll figure it out.
Maybe in the end it's still an accept the RA or reject the RA.
Okay, sorry, Peter Pankey with the division. I just want to understand, so Finley owns, we've been talking about Finley a little bit in that they own certain leases that they're sharing with Percussion now, it sounds like. But those are in 4 and 5, is that correct? Or 4, section 4?
Are you speaking about Finley or Bayless?
Bayless, sorry.
Yes.
Bayless.
So we have the agreement we have with Bayless covers sections 4, 5, 9, and I'm leaving off another section, I believe, in this.
16?
16 is the Stitla lease. We took that ourselves. But I know 4, 5, and 9.
Yeah, but so this was before Bayless had any interaction with Percussion. Is that correct?
That is correct.
Since this is a year ago.
I don't know if, just for clarity, I don't know if I can say we hadn't had discussions a year ago about this acreage,
Right,
but
yes, sorry.
we did not have an executed agreement. Correct.
There we go.
Thank you.
Okay, I'm sure where we are at this point. Okay, go ahead and continue, Mr. McDonald, then.
Thank you. That concluded my rebuttal presentation with Mr. Pitzer. Now I'm going to recall Mr. Atkins
Okay.
on rebuttal. Again, Mr. Atkins, you're under oath here. Can you address, again, let's start with the concept of J and U wells. I believe Mr. Brinkerhoff stated that none have been drilled in Utah. Are you aware of any J or U wells that have been drilled in Uintah?
Yes, yeah, there are in fact 2 J wells that have been drilled and completed in the Uintah Basin.
And
Not by Finley, but by an adjacent operator.
is it something that Finley would consider as a prudent operator if the circumstances justified? Can they be economically drilled?
If it makes sense economically and as a prudent operator to develop the lands that we hold to properly represent the leasehold that we control, yes, the technical capability has been proven in the basin. It will be continued to be proven up through other parts of the basin, similarly to the longer laterals, which is what Finley is here requesting the ability to do today.
All right, I'm going to turn your attention to Exhibit E, which has already been admitted in Petitioner's Exhibit E, which has been admitted into evidence already. Can you address how, if Section 9 and 16, which they want to include as well, how would sections 9 and 16 to be developed under your requested modified DSU?
Sure. Yes. So previous, was it actually, can you go to a different slide?
Which slide do you
The one
want?
that has the arrows.
Oh, yes, okay, instead referring to J2.
There we
Okay.
go. Yeah, so Exhibit J2 is illustrative to show the reason for the request that Finley is bringing to you today to grant us the ability to drill these longer than 2-mile lateral wells. The intent, and so that's just an illustration to show why we're making our request. The intent for the eastern half of the DSU shown there on the map on the right is to drill those as approximately 10,000-foot laterals. So the remainder of the DSU will be developed as approximately 2-mile laterals as shown here. The arrows that are shown are purely illustrative to show why we're making the request.
And again, that's consistent with your plan of development to test this eastern portion with 2-mile laterals initially.
That's correct. And Finley's been putting significant effort into staking and identifying surface locations and filing permits. As Mr. Pitzer testified, we have 12 approved permits already in the immediate area adjacent to these lands with plans to be developing in this area. And so we're preparing to properly recover all the resource on the lands that we control.
That concludes my rebuttal presentation with Mr. Atkins.
Okay, Mr. Eccles?
Yeah, Mr. Atkins, would a J well drilled in sections 5 and 8 be economic in your eyes?
5 and 8.
I'm not testifying as a reservoir engineer. I'm saying that it is technically capable based on what other operators in the basin have done, and that it has already been done twice in the basin. Finley is focused on operating the lands that we currently controlled, and you already testified that we don't have interest in sections 4 and 5. So we're focused exclusively on the lands that we do have interest in.
Yeah, my question was regarding 5 and 8 in the USM side.
It's been proven twice in the basin.
Any other questions? Mr.
Apologies, that's all for this witness.
Okay. Mr. White?
Yeah, just to follow up there, you said you know of these 2 J wells that have been drilled. Do you know whether they've been economic?
I'm not familiar with the economic scenarios of those wells. It's another operator. I'm not sure their cost or the price that they're getting for their crude. There's a lot of variables, the royalties. There's a lot of variables for economics. I'm only stating that the fact that they have been technically accomplished in the basin.
Okay, thank you.
Sure. Board, any questions? This witness, go ahead.
Yeah, I just want to understand, just to say it bluntly, why not include 4? Is it timing? Is it just give me
Sure.
your best reasons why not?
I mean, the first obvious reason that was testified is we didn't have interest in the section.
Yeah.
And so we're focused on the lands that we operate. The second being the nearest lateral longer than 10,000 feet in the basin is roughly 15 miles away. And so as you step into different parts of the basins, you see different drilling hazards, different drilling scenarios that we want to fully understand, and that's what we're coming to request the ability to do, right? It's all progression as we see through many requests for agency action. And so Finley's following the same progression and asking for the ability to do that on the lands that we operate.
So in other words, you really want to just test it on a couple, not across a whole section.
That's correct.
Is what you're saying?
That's correct.
Okay.
Assuming success on those, then we would certainly look at other opportunities on the lands that we operate.
Okay. It's kind of a loaded question, but if you did own 4, would this request include 4?
That's hard to say.
Yeah. Any other questions, board?
Does Finley,
Go ahead. Yeah.
does Finley have any interest in 4 and 9? Any leasehold interest?
I'm going to have to let Mr. Pitzer.
Yes, I believe we do.
Okay. In both of those sections? Some?
Your
Yes,
mic is
some.
muted.
Okay, thank you.
Why you still have it? So as the drawing we have, all in green is controlled by Finley.
Yes, under the 47020 order, it
Under
already is.
47020.
Yes.
Yeah, the parts that are in section, cross line, section 16 and 9 are currently,
Right, basically to the east of the diagonal line is 6 south, 19 east in the Salt Lake Meridian. Everything to the west of it is 2 south, 2 east in the Uintah Special Meridian.
right. Okay, thank you.
Where am I now? Who's?
If everybody's done with
Oh,
that.
yeah,
then we're done
you're
with-
still on
We're
rebuttal.
done with Mr. Atkins' rebuttal, and that concludes our rebuttal presentation.
Okay.
So at this point, I
Okay.
think it's the division's turn.
Right.
We don't have any evidence to present, Chairman Walker, but we would request 10 minutes to evaluate the evidence so that we can come back and make our closing statement.
Okay, so why don't we take, let's go ahead and get lunch and all that stuff taken care of with one break here. Rather than take a 10-minute and then come back and stuff, and so why don't we just take until, what is it, until?
It's only 11:15.
11:15, oh, okay, never mind.
I could probably do it in 5, Chairman Walker.
Let's take a 10-minute
Give
break
you
then.
7.
Yeah, let's come back, let's come back at 11:25 on that clock.
Thank you.
Yeah, okay, thank you. Okay, thank you. We're back on the record at this point in time. So, Mr. McDonald, I understand you need to introduce an exhibit.
Yes, I'm sorry, Mr. Chairman, before the break, I need to move for admission of rebuttal Exhibit 2 into evidence.
Okay.
No objection.
Problems? Any problems with Exhibit 2?
No objections.
Okay, thank you. So admitted. Okay, I think we're back to the division now.
Chairman Walker, we don't have any witnesses to call,
Okay.
so we will provide a closing statement. I don't know the order you want to do those in. I assumed it would be Finley first, but
Yes.
happy
I
to
think
go
on
first.
closing statements, do Finley, percussion, and then the division.
Thank you.
Okay.
Back to me.
Yes.
All right, thank you, Mr. Chairman. I'm going to refer the board back to my opening remarks on a lot of these issues with respect to percussion's objection. First of all, the 47020 order is in place, and it's been in place, and the only thing that's being moved is one boundary line over to better develop sections 5 and 8. If you recall in the exhibits and the testimony, if they were stuck with the existing one, they'd have to drill very short laterals, less than even a 5,000-foot lateral, to develop those sections. This way, it allows them to develop their sections under the existing orders. It's just a matter of moving it. We're not changing anything else. Most importantly out of that is the fact that the 330-foot setback that was set in the 47020 order was a decision based on the fact that nobody in 4 and 5, the adjacent lands, their correlative rights are not being affected. So they can't complain that their correlative rights are being affected. Secondly, the 47020 order was in place before percussion ever acquired any interest from Bayless. Rebuttal Exhibit 2 shows that Bayless, who at that time owned the federal lease covering Section 5, had no concern about their correlative rights being affected or development of those lands. None of that was ever raised at that time. I am very concerned about the board requiring an operator who does not own the lands being required to develop those lands absent drainage or impact. That's a very dangerous precedent to set, to require that, to have them respace and develop lands if there's no drainage occurring on that side. They have an obligation to their lessors not to dilute their interest. If you add in Section 4, that's a tremendous jump in acreage in a drilling unit that dilutes Finley's owners and increases Percussion's owners and their share of the production. And they aren't doing anything about it. Now, committing waste is depletion of a reservoir or anything else. Percussion knew coming in, by taking those leases, they would have their own independent requirements to develop their leases. Okay? There's no obligation for Finley to have to develop their leases for their benefit. There's still no indication why they can't drill a vertical well. There's still no indication why they can't drill a short lateral horizontal well. There's still no indication why they can't drill a U or a J well. It is being done in the basin, contrary to what was said. And most importantly, if they want to develop a 3-mile well or longer horizontal well, they haven't made the effort to work with Section 34 and 35. And to say just because there's a diagonal line there doesn't mean they can't create a drilling unit which still provides them the opportunity to drill those wells and develop their minerals. Finley does not have that obligation. So we request the board to approve the request as submitted. And finally, again, the procedural matter is you can't amend the request at this point to add Sections 4 and 5 because there hasn't been proper notice to it.
Okay.
So again, we would ask that you approve the request as submitted and allow Finley to develop its lands as a prudent operator would be, and for it to allow itself to protect itself and its lessors as it's legally obligated to do. Thank you.
Thank you. Okay, Mr. Eccles.
Thank you, Mr. Chairman. Our position essentially boils down to trying to avoid stranded acreage. We think that if these lands are not included, it makes the most sense to include them with the lands lying to the south and west because of the offset from the lands to the north, making it even more awkward to make a unit with those lands in 33 and 34. So essentially this, for Percussion, comes down to trying to avoid stranding these minerals and, increasing the likelihood that they'll never get developed. We don't disagree with the technical or legal accuracy of any of the arguments that Finley has made today. We just think that it makes more sense if we were to space this to include 4 and 5.
Okay.
And that's all.
Okay.
Thank you.
Thank you. Division.
Thank you, Chairman Walker, members of the board. As everyone is aware, the division originally indicated that it supported Finley's request for agency action, and the division filed a response to that effect. However, that was based on the information the division had at that time. Of course, after the division submitted its response, Percussion presented its objection. We've now seen additional exhibits that have been submitted and heard the witness testimony today. So based on this updated information, there really is a good, better, best principle at play here. The division does believe that Finley has a good proposal here, but after review of the evidence, it believes that Percussion has the better proposal. The division believes that Percussion's position on this provides for maximum recovery and that will minimize waste. And the division is also concerned that ignoring Percussion's request could leave mineral in Section 4 stranded. So I want to talk about some of the evidence that was presented to the board today. We didn't really hear much from Finley about how Percussion's proposal would cause harm. Yes, it appears there would be some delay, but the harm has not been articulated through witness testimony. We heard about correlative rights concerns, but that was also not articulated by the evidence. The one thing we did hear was that it's 15 miles away that wells this long have been drilled, and there is some risk. But we would point out to the board that even in Finley's proposal, that there will be a very long well. So it seems like they're willing to take the risk in that instance. So that doesn't seem persuasive. Accordingly, one other consideration. The division is concerned about the notice issue in Section 4. Based on the evidence today, it appears that there are owners in Section 4 who are not on notice of this proceeding. Accordingly, the division recommends that the board continue any decision on Finley's request for agency action, pending the filing of a separate request for agency action by Percussion, which should of course include proper notice to all the owners in Sections 4 and 5. So the division believes that there should be a separate proceeding with proper notice, and these issues can be hammered out with a decision by the board with all interested owners in mind. Thank you.
Okay, having heard all three rebuttal or closing statements, I think we will take a lunch and a deliberation break, and let's come back in at 12:15. Would that be? Let's come back in at 12:15. We'll reconvene at 12:15, and we'll wrap up this topic. So we are off the record. Okay, everybody, welcome back from the lunch break, and the board has deliberated, and you've given us a lot to talk about during our deliberation, so we appreciate that. So with that, we'll go ahead and ask if there's a motion.
Yes, I'd like to make a motion, but I'd like to preface this motion with a couple of comments. First of all, I feel it's very difficult when you have survey boundaries coming together and making all of these irregular sections. However, I would like to propose that the RAA be granted as Finley has requested, because they have dotted all the I's and crossed the T's. And I also feel it's an inconvenience for Percussion to have to put together a larger drilling unit to make sure they get 3-mile wells, but they've got plenty of room to go to the north, like Finley has gone to the south. So I would like to propose that this RAA be granted.
Second.
Okay, motion's been made and seconded that the request for agency action be approved. All those in favor say aye.
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 All those opposed say nay.
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 Let's go ahead and poll the board, please.
Ms. Selma Sierra, how do you vote?
Aye.
Mr. Stephen Church, how do you vote?
Aye.
Mr. Alan Walker, how do you vote?
Aye.
Mr. Gordon Moon, how do you vote?
No.
Ms. LaVon Garrison, how do you vote?
Nay.
Mr. Patrick James, how do you vote?
Aye.
Mr. Greg Galecki, how do you vote?
Aye.
Okay. Okay.
Mr. Chair, I have
5.
an inability to account.
There's 5 ayes and 2 nays.
That's correct.
Okay. Okay. Okay, thank you. Okay, so also in addition to Mr. Church's thing, I would like to request that, I'm not going to order, but I'd like to request that Finley, after Finley completes the first 2 wells on this drilling unit, that you come back and review with us what you consider the waste situation in this particular area, not just your drilling unit, but also the adjacent units. And I would like to urge you guys to go out there and, keep working through it. But without having your position perfected with Bayless and the BLM, it's hard for us to rule otherwise. But you did sway some people. Thank you. With that, Mr. McDonald, could you draft the order, please?
Certainly, Mr. Chairman. I'll
So-
make sure it goes to the division and board council.
Okay, go ahead, Gordon.
Yeah, my comment, my no vote, nothing against Finley's request. I just think that percussion's option makes a lot of sense. And so I would just like to encourage that the discussions continue, just that they continue. So.
Okay, any questions on any part? Okay, thank you very much.
Thank you.
Thank you.
Okay, we're going to go on to agenda item number 6, which is XCL. So while you guys come up, we'll go ahead and read this into the record.
I only say too much when the mic is on.
Agenda item number 6 is docket number 2026-039, cause number 139-175, in the matter of request for agency action of XCL Resources LLC petitioner for an order to certify petitioner's equipment as a pollution control facility located in Duchesne County. Let's take appearances.
Good morning, Chair Walker and members of the board. My name is Steve Young.
Your microphone's on mute.
Good morning, Chair Walker and members of the board. My name is Steve Young. I am a state and local tax attorney at Holland and Hart, here on behalf of XCL Resources LLC today. With me is Trent Morgan, also of Holland and Hart, and we have a couple of fact witnesses, Dan Shea and Parker Dalton, who will be appearing remotely.
Okay.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining, and I also have with me division staff Adam Miller and Orlin Wallace. Thank you.
Okay, thank you. All right. Let's go ahead and start then, Mr. Young.
Thank you. This has been an anticipated day. I have appeared in similar cases before the DEQ and the Tax Commission many, many times for many, many years. But effective May 31st or May 1st, 2024, the legislature passed House Bill 373 in the 2024 session and transferred authority to approve pollution control sales tax certifications from DEQ to DOGM. And so this is the first time I'm aware of that this board has considered a pollution control sales tax exemption issue. So it's something we've been looking forward to and anticipating. And as a state and local tax practitioner in the state for 30 years, I've been dealing with these issues for a long time, just not before this body. So I've been watching with great interest to see how it works, how it operates, and how the board operates. I'm usually in front of the Utah State Tax Commission or, like I said, DEQ, which has had this pollution control authority for many years. But given that this is the first time, I want to just provide some brief context and background for why this law exists and where we are. It starts in 1973, 53 years ago. That year, the legislature joined what several other states had done in passing an exemption, a sales tax exemption for pollution control equipment. Many states have property tax exemptions for pollution control equipment and also sales tax exemptions. The basis for the exemption in Utah and elsewhere is this. It's very poor tax policy to impose a tax on a government mandate. When I say that, I'll use pollution control as an example. The federal government or the state government comes in and mandates that a taxpayer incur some substantial burden. In this case, pollution control. They come in and say, hey, you need to do this to protect the air, do this to protect the water. It often costs millions and millions of dollars. And then if the government comes in and imposes a tax on top of that, so you spend, let's say you spend, $3 million putting some pollution control device in, then the government comes in and says, we're going to tax you on top of that at sales tax, 6 or 7%. That's doubly punitive on the taxpayer. They have to spend the $3 million on the pollution control item. Then they have to pay another 7% in tax on top of it. So it's doubly punitive on the taxpayer. But then secondly, it creates an inappropriate incentive for the government to impose too many mandates. Because if the government can raise money just by imposing a mandate, you know, most taxes are imposed on private economic activity. But if the government can impose a mandate and then the taxpayer has to pay tax on top of that, the government's incentivized to impose more mandates so that they can raise more money. So because of those two factors, most states, including Utah, exempt from sales tax pollution control equipment, because pollution control equipment, by definition, as we'll get into, is something that is created generally by a mandate of EPA, DEQ, DOGM, you know, some other governmental body. So that's basically why the exemption exists. It's been around a long time, and this is also a very unique exemption. I handle state and local tax cases of all kinds, and we have 80 some odd exemptions in this state for various reasons, and almost all of those go directly to the tax commission. This is the only one I'm aware of that gets administered, and this goes back to the 70s, by a separate state agency. And the reason for that is that the tax commission doesn't have the expertise to determine whether the primary purpose of a particular item is for the prevention of air pollution or water pollution. That's why they've assigned that out to the DEQ for 50 years. And then in 2024, the legislature said, no, for items regulated by DOGM, we need to assign those over to DOGM, because we kept coming before DEQ and having them opine on whether DOGM regulated items had as a primary purpose the prevention of pollution. And they would often throw their hands up and say, that's not our area. We don't deal with that. That's DOGM that deals with that. So finally the legislature in 2024 said, okay, well then instead of asking DEQ to do something that they don't really do, let's move that over to DOGM, which is what happened in 2024. So here we are. So around 2012, we had several cases in front of DEQ, and the DEQ actually said, they came out with an administrative rule and said, we will only certify something as pollution control if it's in a DEQ order. That, you know, if we mandated that happen. And we said, well, wait a minute, what if DOGM mandated that it happen? They said, that doesn't count. We said, what if we voluntarily do it? Doesn't count. What if EPA mandated it instead of DEQ? Well, there was a little bit of discussion. We said, let's sit down and talk about this. So in 2012, we actually went hand in hand, Tax Commission, DEQ, and the taxpayers community. I think I was working with the Taxpayers Association or the Petroleum Association or somebody at the time, and we all went hand in hand to the legislature and said, let's fix this to make it clear that it's not just a DEQ mandated item, it's any mandated item or any voluntarily installed item. If somebody chooses to put a pollution control item in themselves, we don't want to discriminate against them. They still did it for the primary purpose of preventing air pollution. So we need to have all of those certified, and everybody agreed. We got the bill passed in 2014, and so we went on for 10 years under that statute, but because it was clear then that DOGM mandated items were required to be certified, and DEQ, every time we had a DOGM mandated item, just kept saying, well, we don't really know or understand this as well as they do. Finally, the legislature moved it over here. So that's really the background and how we got here today, and why in 2024, House Bill 373, sponsored by Representative Snyder and Senator Sandel, moved that certification authority from DEQ to DOGM. So that's just a little bit of the background and precursor to what brings us here today. Well, the substantive issue before you today involves a gas pipeline built to comply with Utah laws that prohibit the flaring of gas in an oil field. XCL built the line to comply with the Utah laws to prevent air pollution. And we'll get into the specific testimony on this. Our witnesses know far more about it than I do, but basically XCL had ramped up production significantly, and those who purchased the gas had limits on how much they could take through the interstate pipelines. And given that there was a non-flaring requirement in the old days, before the flaring statutes were put in place, they just would produce all they wanted and just flare it. You know, they're producing oil. Almost all of the production in this field is oil, but then they have this gas that comes out that's a byproduct, and they were just flaring it out into the sky. And then, you know, there came a time they could provide some of that gas, and it would go through the interstate pipelines to others. But then they had so much it couldn't go through the interstate pipeline, but they wanted to keep producing the oil. And so they built this gas pipeline basically so that they could keep producing. But it was because of the flaring requirement that they built the line, and it cost them $50 million to build it. They never had any intention of recovering the return on that investment or a return of that investment. They just had to build it in order to keep producing oil and, you know, providing economic benefits and jobs for the state of Utah, and for, you know, providing the money to Sitla and everything else that happens through production. So instead of just shutting in, they chose to continue to produce, but it was because of that anti-flaring statute that they had to build this line instead of just flaring it out into the sky. But they never had any intention on making money from it. They just had to spend the $50 million in order to continue operating. So because of that, the primary purpose of that gas line is prevention of air pollution. And that's what the statutory standard is that you have to apply. What is the primary purpose of this device? And it can be different for a particular item. You know, sometimes you might buy one type of item and it has a primary purpose of something. And there, excuse me, there are certainly a lot of gas lines out there that are not built for the primary purpose of preventing air pollution. They're built to sell gas. But this one was not. As the testimony will show, this one was built to prevent air pollution. This gas line is really functionally no different than a water disposal pipeline. Those pipelines in oil and gas fields have long been certified by DEQ as pollution control equipment because they put water back into the earth and thus prevent the water pollution that would result if the water was just dumped on the ground or into a river. With the gas line, the same thing is happening, as the line prevents the gas from being flared. However, a question arose at the division because rather than shooting the gas back into the ground, XCL figured out a way it could sell it. And so some of the gas is sold to Bitcoin operators and others who put facilities out there because they had this gas available and that they could use it. So because it's sold, it creates an interesting dynamic. And because this is a new issue, we presented it to the division, and they came back and sent us an email. And if we can put that on the screen, I just want to set the table for the sort of the procedure here because it's new. But basically, it says, this is a relatively new legal framework, and the board is best qualified to make the final determination on it. So the division just said, hey, you know, there's a lot of gas lines out there that their primary purpose is to sell gas. You know, this is a different kind of gas line because it's got this other purpose, and so we don't feel like we want to jump in and make that decision. We want the board to make that decision. So that's basically why we're here. We're asking you today to certify this gas pipeline as pollution control equipment because the primary purpose of the line is the prevention of air pollution. And you may say, wait a minute, if the non-flared gas is being sold, doesn't that by itself disqualify it? And the answer is no, because the test is a primary purpose, not an exclusive purpose. You can have more than one purpose for an item. Let me give you a few examples. The water disposal lines that I told you about, sometimes oil and gas operators will sell some of that water. It doesn't change the fact that the water disposal line is put in to prevent water pollution. The primary purpose is still the prevention of water pollution, but it has another purpose of selling some of the water. If you can find somebody that can use it and you can sell it to them, that is still acceptable. Another example is in a power plant, a low NOx burner. The DEQ has long certified low NOx burners at power plants as pollution control equipment for sales tax purposes. But guess what? Those low NOx burners have two purposes. They prevent air pollution as opposed to non-low NOx burners or high NOx burners or whatever they call them, but they also produce power. You can't produce power at a power plant without a burner, but the primary purpose of that low NOx burner is to prevent pollution. This is because power could be generated without low NOx burners, but the power plant spends millions and millions of dollars to install low NOx burners to prevent air pollution. The fact that the burners also generate power is not disqualifying. Another example is a solar pump in an oil field or oil and gas field. The field is operating without solar. The operator then spends millions of dollars to convert this to solar. Are those conversion costs incurred for the primary purpose of preventing air pollution? Absolutely. That's the only reason that you convert to solar, is to prevent air pollution. This is true despite the fact that those pumps still help pump oil or gas. You can have a secondary purpose to these costs, and that doesn't disqualify them from having as their primary purpose the prevention of air pollution. The gas line to prevent flaring is the same. Oil fields could and did produce oil by flaring gas in the past. Then, to prevent air pollution, some oil fields started installing gas pipelines to avoid flaring the gas if they had flaring requirements, and it's in an oil field, etc. The gas pipeline installed to avoid this flaring is installed for the primary purpose of preventing air pollution. The pipeline is a clear government mandate. Utah law requires it to avoid flaring. To turn around and impose sales tax on that government mandate flies directly in the face of the legislature's decision not to impose sales tax on government mandates like this. You might also ask, but you built this to keep operating. If without it you would have had to shut in those wells and you couldn't keep operating. Well, you're still operating, and that overall big operation was your primary purpose. But that argument flies in the face of every piece of pollution control equipment. If power plants, oil refineries, and manufacturing facilities do not install pollution control equipment, they will all be shut down. They thus install pollution control equipment to allow them to keep operating, but it does not grow the pie like so many other capital investments in business. It's just something the government makes you do to prevent air pollution, so it keeps you from shutting down and allows you to keep operating. But if that was the test, then there would be no such thing as pollution control equipment in any industry, because every piece of pollution control equipment allows companies to continue operating and to continue doing what they do to run their business. So that's basically the lead, and I'd now like to address a few of the specific issues raised by the Attorney General's office in response to our petition. So if we could pull that up and put it on the screen. The first point made by the response is that the division, as is highlighted, has not adopted a policy that would identify the primary purpose of a gas gathering pipeline as pollution control. That is understandable, as this is a brand new issue with DOGM and the division. We're clearly understanding that there's not policy, but that's why we're here. This board is the board that's been designated under Utah law to decide what should that policy be and what that policy should not be. So that's what we're here to do, is basically ask you to adopt that policy and to declare this to be pollution control equipment because of its primary purpose. Secondly, let's go down a little bit. The response says the pipeline was installed pursuant to the prohibition of waste and not pollution control. And then it says down further on the next page, it appeared that the primary purpose of the pipeline equipment was to comply with the waste regulations, implying that there's some sort of mutual exclusivity between waste regulations and pollution control. But this is missing the entire point of pollution control. Pollution control is the prohibition of waste, and the prohibition of waste is pollution control. Every pollution control device out there is put in place because of a statute that prohibits waste. It's the government mandating something to the business community. You can't do that anymore. You have to put these low NOx burners on, or you have to put these solar pumps in, or you have to put this water disposal line in, or you need to put you can't flare your gas. And that's exactly what's happening is we're prohibiting waste, but that is pollution control. So basically the response is supporting what we're saying because it says the primary purpose of the pipeline is to comply with waste regulations. Bingo, that's exactly our point. It's to comply with waste regulations, which is saying it's the primary purpose is pollution control. We agree with that. Thirdly, they mention in the next clause right after this highlight that there's a purpose to facilitate natural gas sales. And we agree there are sales that we have made to these Bitcoin operators and others that exist, but those were not the primary purpose. We lose tons and tons of money by putting this line in. Those were just to try to cover some of the costs, the $50 million that we had to spend to do this, but it's not the primary purpose. Let's now go down to, there's a clause, or the next heading down below this, right here. There we go. The petitioner has not demonstrated how the gas gathering pipeline will affect air pollution. But XCL clearly has, by establishing that the line was built to avoid flaring, as our witness testimony will show. That the line avoids flaring is clearly established and undisputed. The other question raised is whether the Bitcoin and other operators who purchase the gas create as much pollution with the gas as is avoided by flaring it. But the answer should be obvious, or else the state law prohibiting flaring would be nonsensical. If flaring creates less pollution than piping the gas and selling it, why not just repeal the law that prohibits flaring and let people flare it if it's not preventing air pollution? The very fact that we have the non-flaring requirement and that it's forcing people like XCL to build these $50 million lines, it's obvious that avoiding flaring prevents air pollution. And also of note, whoever buys this gas, the Bitcoin operators or whomever else, they're prohibited from flaring too. So it's not like you can just pass it off to somebody else and then they can flare it. There's clearly air pollution being prevented by putting this $50 million line in. There's a similar point right below this in that third line down that says the pollution control equipment must prevent, control, or reduce air pollution by disposal, elimination, or reduction of the air pollutant. 100% what we're doing. Because we put this line in, we're not flaring. We are therefore eliminating and reducing air pollution by what we are doing with this line. And then lastly, the division says, the division is unaware of any evaluation related to losses or profits generated by the applicant to determine whether freestanding pollution control properties should be certified. Basically, we don't want to be in the economics business of having to sit down and figure out in every case, there's nothing in the law that requires us to do this analysis of profits and losses. And this is clearly true. There's nothing in the law that says that DOGM has to sit down and analyze profits and losses. XCL raises the losses because that is one obvious method to determine if a gas pipeline was built for the primary purpose of preventing air pollution or not. If the primary purpose of the pipeline was to generate a profit, no rational business person would spend money without expecting a return. You are not required to consider losses, but you are required to determine whether the primary purpose of the gas line was to prevent air pollution. The presence of the losses helps inform that issue. You might reasonably ask, should every gas pipeline be certified as pollution control? The answer is clearly no. Many gas pipelines, I would say most gas pipelines, are built in gas fields to transport gas for the primary purpose of selling the gas. These are not built for pollution control. They are built, like most pipelines, to generate a profit. Midstream pipelines would fit in this category that transport gas. Pipelines that don't have flaring requirements, because they're not, flaring requirements are applied to operators of oil fields like this, which have a byproduct of gas that then just flare it out into the air. But if you're not in that flaring context and you're some sort of other kind of gas pipeline, clearly this wouldn't apply to you. An eligible line is one as is at issue here. In an oil field with flaring requirements built to avoid flaring gas that was a gas line that was built with no hope of making money. Those lines should be certified if the primary purpose is the prevention of air pollution. So that's basically the issue before you. It's very straightforward. If the primary purpose of the XCL gas line is to prevent air pollution, you should certify it as a pollution control item. And with that, we have a couple of witnesses to call, but I can't remember from this morning what the next step is, if the division goes or if we call our witnesses. We're happy
The
to
next
follow
step
whatever.
would be for, sorry. The next step would be for your witnesses to be sworn in and go ahead and
Sounds good.
take their statements.
We have Mr. Daniel Shea, who's a vice president of production, facilities, and infrastructure with XCL. Would like to call him first.
Let's swear both your witnesses in, please.
Sounds good.
Daniel Shea, and who was the other?
And the other is Parker Dalton, who's the vice president of accounting at XCL.
Okay, and then you also need sworn in, or?
Mr. Morgan is an attorney
okay.
with our same law firm, so he's just here because all the slides were on his computer.
Okay, please raise your right arms to the square. Right arm, I guess you just have one of them. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Shea, can you please state your name and title and business address for the record?
Yes, I'm Dan Shea, Vice President of Production Facilities and Infrastructure with XCL Resources LLC at 300 North Shepherd Drive, Suite 390 in Houston, Texas, 77007.
And can you please give us some of your background and resume as to why you're qualified to speak to these issues today?
Yes, I've been in oil and gas operations since 2009. Worked with EOG Resources, and then after that came to XCL at the very startup of it, and saw it all the way through selling to SM Energy. And so worked for XCL Resources, with the under the production facilities infrastructure job role for roughly 5 years.
And are you familiar with the gas pipelines at issue here?
Yes, I'm familiar with them.
Can you tell us about the decision to install those gas pipelines and why they were put in place?
Sure. Really, the decision to install the gas pipelines was made to avoid flaring during basin-wide takeaway curtailments from Kinder Morgan, who was the sole gas gatherer for XCL Resources, mainly due to contractual dedications. They were also one of the only third-party gas gatherers in the basin. And at the time, they could not mechanically move the new development gas volumes out of the basin without substantial large-scale upgrades. That would take a lot of time to implement. So during during the multi-year gas production curtailment, Kinder Morgan would provide monthly allocations of allowable gas sales to all the operators in the basin. While XCL was growing oil production at a rapid pace, our associated gas production with that oil would often exceed the allocations given to us by Kinder Morgan. The decision in front of us was to either shut in production and stop development due to the flaring restriction rules in place, or to find alternative takeaway for the gas. Due to XCL Resources' substantial investment in the basin, the difficulty in slowing down oil and gas operations due to drilling and frac contracts, and the time-dependent financial obligations to our investors, stopping development really wasn't feasible for us. So we opted to find other ways to get rid of the gas through substantial pipeline expenditures to allow the flexibility for different avenues of gas utilization or offload.
So you testified that the primary purpose of the line was to avoid flaring, is that right?
That is correct.
Was the primary was generating a profit the primary purpose of this line?
No, it wasn't.
And we'll speak to that a little bit more with the next witness, but that's all the questions I have for this witness.
Okay, division.
Thank you, Mr. Shea. So you indicated that that in the basin that Kinder Morgan had their curtailment period. Can I just ask what was happening with the gas prior to the curtailment period?
I don't know all the particulars about what was happening with the gas beforehand, but really before XCL came in, there wasn't as much development going on prior to us arriving. We definitely dialed up the knob there for development and quickly became the #1 oil producer in Utah for a period of time. And so I think for Kinder Morgan, it was kind of like status quo. There wasn't a whole lot of growth happening, and if there was growth, there's also depletion happening around the field as well. So production stayed relatively flat. So the need to grow, pipeline takeaway wasn't really present. And so, but once we came in and started developing, a considerable amount of incremental volumes to the basin, that's kind of when the problem presented itself.
But would it be fair to say there was gas sales prior to the curtailment?
Yes, there's definitely gas sales prior to the curtailment, yes.
So then with these gas sales, even if they were limited, how was gas entering Kinder Morgan's facilities?
For our situation, there's different dedication areas. In some areas, Kinder Morgan was dedicated, or we're dedicated to Kinder Morgan, and they were obligated to come build pipeline to us. And in other areas, our volumes were still dedicated to Kinder Morgan, but we were responsible for building to a central delivery point to them.
Okay, so just help me understand then this subsequent pipeline that has been developed. It's still associated with the Kinder Morgan facilities. It's just separate lines, separate gathering lines.
Correct.
Okay. Lastly, you did indicate that as production did ramp up and your gas production grew, you had the choice to either shut in or find an alternative pipeline. Was there ever any thought as to seeking an exemption before the board as to being able to flare more gas?
I don't recall if we did that or not. I know we were definitely having a lot of discussions with you guys regarding different avenues we could take to try to alleviate the problem. And I think at the time it was like, hey, we can help you interpret the rules and live within the rules, but no solutions were found at the time.
Okay, thank you. No further questions from the division.
Board members, do you have questions? Go ahead.
Are there other gas pipelines that have qualified thus far in the state for the exemption?
If you're asking me, I don't know the answer to that question.
And I can tell you as a state and local tax practitioner, I haven't seen any come forward on this issue before because I wasn't aware that this kind of, people were building them for this purpose. So this is the first time I've seen it. I had never seen one certified under DEQ, hadn't seen one certified under DOGM. So I think it's a case of first impression.
Okay.
It's being presented to you today.
Okay.
If you'd like to address the division staff that's here, I'm happy to. do that too. Do you want me to swear them in? And then you can just ask them questions or however you'd like to do it.
Let's wait till they're done with their
Okay.
presenting their case, because let us ask questions there. Yeah. And then you'll have your opportunity.
So let me just follow up on that question. So where did this gas pipeline go?
Yeah, good question. So a lot of our acreage was pretty consolidated. So, you know, we had the ability to run all of our pipeline, you know, right next to our well pads, and they connected a lot of our well pads together. And what that ultimately did was, you know, it was since they're all interconnected, it kind of centralized the effort of being able to send gas wherever we could to try to mitigate the flaring across the field. It allowed us to control line pressures. A lot of I don't know if any of you guys are familiar with production separator vessels, but a lot of the vessels in the basin were not geared for higher pressure, and whenever the pipeline pressure exceeds the separator pressure, typically it would send the well to flare, or you could make it to where it just shuts the well in. So having this system also allowed us to control our line pressures, you know, because we weren't subject to whatever Kinder Morgan was doing. And it allowed us to send our gas to different places. So, you know, Bitcoin mining was mentioned. We use that to offload gas. Our frac, we would send that to our frac to offload gas. And so we kind of developed the system with that in mind. So we installed a compressor station to make sure, you know, we could deliver gas to different areas at appropriate pressures. So a lot of thought, expenditure, design went into mitigating flaring across the field as we were developing.
Okay. So just a final question. If it were not for the flaring or no flaring requirement, would you have built this gas line?
I mean, it's a good question. I think, you know, XCL was always, you know, our mantra was we're doing the right thing at all times. So, and you know, whether someone's looking or not, and so I think, you know, I think we kind of saw this pipeline as like, hey, this is how we have to do. This is how we're deciding to do business. Whether, you know, we're going to get the benefit of, you know, it being tax exempt later or not. So like, I think you know, it's tough to answer that question, but it would have been a decision made just through our own, you know, business morals, I guess. But I think XCL probably still would have done it if we were going to get an exemption or not. But you know, because nowadays, you know, flaring is, you know, not looked upon favorably, but you know, but also it is a large amount of money we spent to do this.
Yeah. So what I hear you saying is it was the primary motivation, but you may have built it otherwise for other reason. Well, you just don't want to flare, but
right,
but you're saying that it was the primary motivation at the time.
Yeah.
Is that accurate?
Yeah, because yes, I mean, you know, flaring is a risk to the business, you know, because you know, it's like, hey, maybe you don't get caught, but like, you know, once you do, then you know, you guys have the ability to shut it down. So it's definitely yeah, it's definitely part of the decision, or the primary decision.
Thank you.
Yes, sir.
Any other questions? Okay, when was this $50 million investment in facilities done? When was the fabrication construction put in operation, roughly?
Roughly, yeah. Is from when we started operating in, January 2020 all the way until we sold in October 2024.
Okay. And can you give me a rough number as to what was the volume of gas that you were processing on a daily basis, roughly? Or a
Yes.
range?
The amount of gas, I can tell you the amount of gas we're moving through the pipeline, and that was roughly 50 to 60 million a day.
50 to 60 million MMCFD, right?
Yes.
Okay. Okay. So that's probably 100 times as much you can flare legally, all right?
Oh, yes.
Yeah. Okay.
Yes, sir.
Okay. Any other questions on the board? Okay. Go ahead, Mr. Young.
Thank you. Would like to call an additional witness, Mr. Parker Dalton.
Yes, my name is Parker Dalton, and I'm the Vice President of Accounting at XCL Resources, LLC. My business address is 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007. I've been in oil and gas since 2014, all in oil and gas accounting. And I worked as VP of accounting for XCL Resources since we started operating in Utah since January of 2020.
And can you just give us a little bit of your resume and background and why that's
Yes.
relevant to this proceeding today?
Yes, since working in the industry, I've worked in several basins with the public oil and gas company, Carrizo Oil and Gas. Worked at XCL since January 2020, and I was in accounting. I was a part of the team that paid every invoice and was part of these discussions from an accounting standpoint of the $50 million expenditure. And while Dan oversaw all the operations, my team oversaw all the payments and was responsible for accounting for these gas sales and payments.
And did you hear the testimony of Mr. Shea?
Yes, I did.
Do you agree with that?
I do. Am I allowed to speak to one question that a board member asked Mr. Shea?
Yeah, that's what I was just going to ask. Is there anything you'd like to add before I get into some specific questions of you?
My colleague, Mr. Shea, did an excellent job. The only add I would make is, would we have built the pipeline? It's a great question. We did not build it to make a profit, as you will see from this next exhibit. If there was business reasons for being environmentally friendly, to adhere to regulations, etc. But as you will see next, it was not to make money. That's what we have seen over the course of time running the business.
And it sounds like culturally it's become inappropriate to flare. But I'm trying to think back to when I was a young attorney, and I feel like people were flaring all the time. Is that right?
I can't speak to all the way back, but since I've been in the business early on in 2014, I remember operating in Texas for the public oil and gas company, and flaring was much more accepted. And you're right, now it is absolutely not. Also, just from our experience operating in Utah, we had an awesome relationship with Utah. We loved operating there. We'd love to operate there again. And so that we wanted to do the right thing. That was how we wanted to run our business.
And so, clearly you can't flare because of the state law. And even if there wasn't a state law, which was the question that was posed, you may have still chosen to voluntarily not flare because of the, just the culture of our time. But if this was 20 years ago when flaring was more common in the industry, would you ever have built this line at that time?
I can't speak to what management would have decided to do, but I can say this: if you're a board member deciding, well, they built the line for gas sales. That's why they did it. Even if there wasn't flaring obligations, they built it to sell gas. The cost it took us to build a line compared to what you'll see of what we made from selling the gas is so astronomically in the red that it would not have made business sense to build it in any way. So no, it would not have been a prudent business decision to build it.
So if we could turn, this is Exhibit A to XCL's request for agency action, which has already been submitted to the board. And if we could just blow that up so we can see the numbers. There we go. And then if you could just walk us through what this is telling us.
Yes, this exhibit is showing XCL's net loss from building the gas pipelines from 2021 to 2024. XCL paid 100% of these costs to build these gas pipelines, which totaled $56 million. These costs were offset slightly by recouping some revenue from charging a gathering fee to working interest partners that did not pay for any of the lines to be built. Further, this exhibit shows the net gas sales revenue that XCL received. You can see from the $23 million net loss that the decision to build the gas pipelines was not to make a profit.
Sounds good. And it looks like the net loss in 2022 was $9 million, then 2023 was $8 million, then 2024 was $6 million. So it's going down over time. Over time, if you kept this in place long enough, would it ultimately turn around and make a profit?
It's impossible to say exactly, but from looking at this graph and the way wells decline, if we stopped all production and stopped all new development, you stop the cost, well, the wells will eventually decline, and the decline curves would slowly ramp low, so that making up $23 million would be a steep hurdle. So no, I can't say, but my answer would be likely no, and if we did, it'd be small enough to where it wouldn't have made sense. Also, for oil and gas operators like us that are private, we're not public, we have a timeline of our investment to hold that investment long enough to turn a profit. That is not a typical private company endeavor. And so no, that I can't say that we would have.
So would you agree with Mr. Shea that generating a profit was not the primary purpose of this line?
That's correct.
And what would you say was the primary purpose of this line?
I would say the primary purpose of the line was to continue our oil and gas development, and to do that, we were required to build the line to adhere to flaring obligations.
No further questions.
Non-flaring obligations.
No further
Questions,
questions.
division?
Yeah, thanks, Mr. Dalton. So we have a full-year snapshot here. Could you just help me understand some of these numbers? So it looks like every year the cost was going up till 2023. What can you define what costs are in this line here?
Yes, these are costs to provide labor, materials, pipes, all the costs involved to build, dig, and run the line of gas from our well sites and facilities to an outlet point to adhere to environmental regulations of non-flaring. So that cost is simply capital cost. That is not operating cost. That's not LOE. That's simply capital.
Okay. The notation in blue says cost XCL incurred to build and operate the gas pipeline. So are operating costs not a part of this number?
They're not. I'm so sorry. That build and operate to me meant this is the cost to make it functional, operational.
Okay. So the $56 million, that is the cost to just build the pipeline.
That's correct.
Okay. So then by 2024, was the pipeline completed?
We were continuing development. And so as our drilling and completion team was continuing to move around the basin, Dan's team was staying up. And anywhere where there was going to be a issue where we would not be able to produce wells that were ready to be IP, we had to build a gas pipeline to an outlet point.
Okay.
So that we can continue development.
So this does not include operating costs. Let's just take at the end of 2024. You gave a scenario where oil and gas ceased, no more revenue was coming in. Like, this is a massive loss. Let's go the other way. Let's make the assumption that the oil and gas pipeline is finished, and now all we're doing is just running gas through and selling the gas. Do you have any idea what just operating costs would run on this pipeline?
I would say the operating costs are it would not be material. Dan, do you have any input? It was not, I would say, like, you have some maintenance, just some repair maintenance. You have some compressor, if you have to do some compressor costs, like if there's little things, but it would not be super material over time.
Okay. And I apologize if I missed this. Do we not have numbers for 2025?
We sold our asset in October of 24.
Okay, so you no longer have ownership of this pipeline. Okay.
That's correct.
One final question, and again, if you can speak to this, great. If you can't, that's fine. In this cost, are we factoring in depreciation on assets as well?
No, this would just be 100% cost out the door.
Okay. All right. Thank you very much.
Board questions for this witness? Yes. Yeah, go ahead, Steve.
So I'm trying to understand now on the pollution control. Does it transfer to your purchaser, the individuals you sold the pipeline to their ongoing operation of the pipeline?
My understanding is it's the sales tax that is incurred to the way it works with water. If we build a saltwater disposal tank, a pond, or a pipeline, the capital cost to build the line is sales tax exempt. The ongoing operations, you're not. If you're building new lines, they are. So my understanding, for water, if SM Energy, who bought our assets, builds new water lines, they are sales tax exempt. But the pond, the pipelines, I think, Dan, we built almost 80 miles of water pipelines. They're not getting any new benefit of sales tax exemption.
So are you realizing a payout by selling this, or are you writing it off as a loss?
Good question. It's this is maybe a little bit heady, but when we sell our assets, there's negotiations with the buyer and seller that do allocation of value, and the buyer and the seller sometimes come to an agreement through a PSA of how much value are you going to give the water pond, the water lines, the gas lines, etc. For us, as you can see, selling this infrastructure was kind of part of the deal to SM. We built everything to run our business. We might not have had a seller or a buyer. We didn't know when we built these lines we would get a buyer. We didn't know that our investor would like to sell the sales price number. So we couldn't have known that when we made these decisions. I think if you're SM and you come into a basin that was 10 years ago not what it is today, and you have infrastructure built out, definitely made us a more attractive company to buy. But whether we recognize it a loss, the sales price kind of just all goes into the entire piece.
But you will be continuing to sell your gas into this line?
No, so we no longer operate in Utah. And October 1st of 2024, our buyer bought all of our assets.
Okay, thank you.
So this one, yeah.
Okay, so this is, I've been out to your facilities. I think Josh, I can't remember his last name right now.
Ziegler.
Yeah, Josh Ziegler took us out there, and there were many things other than just a pipeline. There were separators, there were compressors and stuff. Is that all built into this $50 million loss that you're talking, or $56 million loss here? What?
My understanding, and Dan can speak operationally, but the way we run our cost centers, the only costs that are going into this was specifically building gas pipelines away from our facilities. If it was a facility cost on a pad, let's say we have an 11 well pad, all the facility costs go to those wells on the pad, because we would be able to share those costs with working interest partners. We would never want to take a loss where we pay 100% of the cost if we could share those costs with other partners.
So then what you're talking about then is purely a gathering system, or predominantly a gathering system, and not the compressors and separators and all those other things that Josh took us out to see.
Dan, unless there is things along that line that were required operation to move gas so we didn't flare it, you would be able to speak to that more than me.
Yeah, you're correct. It's the gathering system only, and then along the gathering system, you'd have to boost the gas. We would deliver the gas to the center of the field, and we had a compressor that would boost the gas to send it to wherever we needed it to go to get rid of it at the time.
Okay. And so roughly, how many wells are we talking about that are behind this gathering system that you're talking about? Because you're allowed to flare at about 60 MCF a day per well. How many wells were sitting out there? That's an important number to me.
At the time we sold, there was just under 150 wells, operated wells, that were connected to this system.
Okay. Okay, so rough numbers then is instead of 100 times, you're about 75 times the amount of gas you're legally allowed to flare. Okay. Okay, I don't have any other questions.
I have a follow-up question.
Go ahead.
Did I understand you to say that there were partners of yours that paid into this well, this pipeline? The
No, sir.
construction?
We paid 100% of the cost for this pipeline. At the well sites where we built gas facilities and oil facilities and compressors and separators on pads, there are working interest partners that are in those wells. Finley, Uintah Wax, Ovintiv at the time, those guys are part of the wells, but this pipeline itself was built just 100% us. Nobody else shared in those costs.
Thank you.
I have a question.
Go ahead.
What is the end point for this pipeline? Is it the Williams system, or is it going to third parties to generate the gas sales?
Multiple outlet points. One is to Kinder Morgan, who is our gas purchaser, gatherer. It's the only one in the basin. Another one is we did have lines that were connected to our electric frac fleet because it was another outlet point. As Dan mentioned, we were curtailed for a lot of the period we were developing. Dan, was there any other outlet point? Oh, the Bitcoin operators was another outlet point just to get rid of it as best we could.
Yeah, we were dedicated to Kinder Morgan, so anything we sold had to go through Kinder Morgan, and then Kinder Morgan would then send it on to, I think it was Questar, then Mountain West, then Williams, and so they were our kind of go-between with those systems.
When did those companies take title to the gas? Was it when it entered their system, when it left the well? When it entered their system?
If Kinder Morgan built directly to the well, which was a small, I guess a smaller, it was a smaller percentage of our wells where they were obligated to build to the wells. Then it would change custody right there at the pad. But since we built this system, all the gas remained ours until it reached a central delivery point, in which it became Kinder Morgan's.
Thank you.
Okay. Just rough numbers here. It looks like you got a fairly decent market price for this gas under your gas sales revenue for the roughly 50 to 60 million a day. Is that a valid statement?
Sorry.
Is that a valid statement? You somewhere around $2 a decatherm or MCF?
This revenue includes NGL sales as well. This is all the revenue we received from processed gas and residue gas.
Okay. But you weren't giving this gas away. You were getting a something like a market price for it.
That's correct. That middle line of the exhibit you're looking at, the gas sales revenue, is everything we received from a purchaser, which was vast majority was Kinder Morgan for that gas.
Okay. Okay. Thank you very much. Any other questions?
And may I add something there? Sure. We would only sell Kinder Morgan what they allowed us to sell to them. So if that was 20 million a day, then that's all we could send to them, and we'd have to figure out what to do with the rest. And so as development went on, they would reallocate amongst operators, but the numbers didn't go up. The allocation numbers did not go up as fast as our production went up. And so those numbers that you're seeing there, the revenue, would have just been on the allocated volumes that we were allowed to sell to them.
Okay. So the gas sales revenue, that only reflects Kinder Morgan, or that reflects what you sold to the Bitcoin guys, or where's that money show up?
That includes the Bitcoin.
Oh, it
but
does.
Bitcoin, it does include Bitcoin, but just one caveat there. Bitcoin came onto our locations at the advantage of getting to buy that gas from us at a much reduced price.
Gotcha. Okay. Fair enough. Thank you. Any other questions, board? All right. Okay, Mr. Young, thank you.
I have no further witnesses or no further questions for the witnesses.
Okay. Division, over to you.
Thank you, Mr. Chair. Really, the reason we're at this hearing today is because the division denied us certification for freestanding pollution control facility pursuant to our process that's outlined in R649-12. Under the rule, the division can certify equipment as freestanding pollution control property if it meets the definition under the Pollution Control Act. Under this statute, equipment must have a primary purpose of prevention, control, and reduction of pollution, and the equipment must dispose, eliminate, and reduce pollution. So the division's understanding of the Pollution Control Act and the requirement for freestanding pollution control property does not allow it to treat gas gathering lines as meeting this definition. The division today is here to outline its understanding of the definition of freestanding pollution control property under the Pollution Control Act and look to the board to determine if the division should alter their understanding of the definition. So with that, I'm just going to give me 1 second. Let's see if I can get this in there. All right. So as I indicated, we have the Pollution Control Act that governs our guidance on how we certify freestanding pollution control property. We also have our rule, R649-12, which the board approved and passed last year. I'm sorry. There we go. So as I indicated, there's a policy question. The division has previously not recognized these gas gathering lines as associated with pollution control, but more associated with the transportation and sale of gas. One of the reasons we're here for the policy decision, Utah Code 40-6-4-1B designates the board as the policy-making body for the division. All right, so let's just look at this rule. Really what this just comes down to is, what is a freestanding pollution control property? What is it? Okay, so we have Utah Code 19-12-1025. So freestanding pollution control property, and I've just highlighted, I guess, what I think the relevant bits. That's all relevant, but in brevity, here it is. So it's if the primary purpose of the tangible personal property is the prevention, control, or reduction of pollution by the disposal, elimination, or reduction of air pollutants. So we have these two elements, okay? So let's look at the first one, the primary purpose of the tangible personal property. So these are questions the division has to ask, and these are the questions that the board's gonna have to ask themselves. Is the primary purpose of a gas gathering line to prevent, control, or reduce air pollution? We've heard today the term waste. Okay, we're very familiar with waste, but it has multiple meanings. Waste for us under 40-6-3 refers to the waste of oil and gas. And we are told by statute the waste of gas is prohibited. So what does that mean? It means we do not allow operators to go out and waste oil and gas. They cannot overproduce without a market. They cannot drill too many wells and drain reservoirs so that they can't get all the oil out. We also have in our code, waste is defined to include the production of oil and gas in excess of transportation or storage facilities. So when we have an operator come in and they want to drill a oil well and there's going to be gas production, it's an oil well with gas production. The associated gas cannot just be wasted. We cannot let them do whatever they want with it because we're prohibited by statute. That's why we have flaring rules. We also have a flaring rule that's put in place that limits the amount that an operator can flare. Currently, it's 1,800 MCF per an oil well, subsequent to an exemption from the board. So can the division recognize that operators must prohibit the waste of gas when permitting and operating a well by requiring sufficient gas takeaway, and also identify transportation lines as having a primary purpose of pollution control? So this comes back to, what is the primary purpose of this gathering line? Is it to prevent waste? Is it to prevent pollution? I'll just add in here that our waste statute does not have a pollution element to it. It's nowhere in our statute. It's not mentioned. We are not given a mandate to prohibit air pollution. We're given a mandate to prohibit waste. The second element of the definition requires the disposal, elimination, or reduction of air pollution. So this brings us to the bigger question: is natural gas a pollutant or a commodity? We treat it as a commodity. That's why we don't want it wasted. Does flaring produce air pollution? Of course it does. We don't need to have testimony on that. We know what happens when we flare gas. But what's at issue here today is the actual gathering lines. We were given gathering lines, and we were asked, were the primary purpose of these gathering lines to reduce waste, to dispose, eliminate, or reduce air pollution? So then the question becomes, right? We can look at them one by one. Do gas gathering lines dispose of a pollutant? Do gas gathering lines eliminate a pollutant? Do gas gathering lines reduce a pollutant? Well, I've got some grammar errors there. I apologize. But really, again, what was the primary purpose of the gas gathering line? That's what the question that the division has to answer. That's the question you're going to have to determine. Based on the division's experience, when they have been presented with these issues, their answer to this question was the primary purpose of a gas gathering line is to transport gas to a sales point and sell the gas. We've heard a lot today about economic factors. There is no economic analysis involved for us when we look at the Pollution Control Act and the certification of freestanding pollution control equipment. We've heard about there was losses. We've heard that we would never have done this because just for sales because it wasn't economical. We just don't have that element in our analysis. That's not what we're asked. We're asked what was the primary purpose of the equipment, and that's what the division had to look at. As it comes to oil and gas equipment, that brings a whole new dilemma. How do you evaluate the economic value of oil and gas equipment? We all know how oil and gas works, right? We have our ups, we have our downs. We have times when their wells aren't producing much. We have times when we've just found a new technology and we produce tons of oil because we can put more wells in the ground. So we saw their exhibit that showed this snapshot. If we were required to put any kind of economic analysis in there, I don't know how we would do it. We have this area of land that there may be a few wells in there. 5 years from now, those wells could have doubled or tripled, and the gas takeaway could also have doubled and tripled. And at some point, that facility could become economically viable. We just don't know. We don't perform that analysis. So oil and gas operations and associated revenues are always in flux in oil and gas. So can profitability be a reliable indicator as to primary purpose of freestanding pollution control property? Again, that's a question that the board's going to have to ask themselves. So in conclusion, based on the division's understanding of the Pollution Control Act, they were not able to certify the petitioner's application for freestanding pollution control property. Absent policy direction from the board, the division will continue to not recognize equipment purchased for a natural gas pipeline as satisfying the criteria for certification. And so now it's up to the board to decide if that's the direction they would like the division to go. At this point in time, as I indicated, I have 2 division staff with me. They're here happy to answer any questions that you may have on the processes that the division goes through, or any specific questions related to this permit. But other than that, I have not sworn them in, but if we do, I would suggest we swear them in.
Please do swear them in.
Please raise your right hand. Go ahead and stand too. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God. Thank you.
Before we have the board ask you guys any questions, why don't you go ahead and really give us a quick overview of your knowledge of gathering systems and productions, and just your career real quick. Go ahead, Mr. Miller first. Yeah.
Adam Miller with the Division of Oil, Gas, and Mining. I have about 24 years experience in the oil field. I started out as in the wireline industry, and then moved to the production side, where I moved myself up to production superintendent over a field. And I started here at the division 4 years ago. And so I take the PCF applications and do the initial reviews on them.
Okay, thank you. Mr. Wallace?
Orland Wallace, permitting manager for the Division of Oil, Gas, and Mining. So I've been been in the oil and gas industry for 35 years. Worked on drilling rigs, worked wireline for Schlumberger and JW Wireline. I also have done downhole fishing tools, fishing oil and gas equipment out of the hole. I also worked for EOG Resources as a pumper. So I pumped gas wells out south of Vernal, Utah, and their little basin out there. And then I also owned my own oil and gas fishing tool business, and then came to work for the Division of Oil, Gas, and Mining when I sold that. I started out here at the oil and gas, started out as an inspector, and then worked my way up to become the division's permitting manager.
Mr. Wallace, how long have you been at the division?
I've been at the division a little over 8 years, 8 years and about 3 months.
Okay. Do you have any objections to them answering questions or being witnesses?
I do not.
Thank you. Okay. Board, do you have any questions of the division?
Questions?
Yeah, go ahead.
So back to the question before, have you had other requests for pipelines to be certified?
No, we haven't.
It's the first one. Okay. What are some other? So you've been doing this for a couple years. You've had other facilities requested that you've denied?
No, this would be the first one.
Okay. Okay. And just in your words, quickly, why did you deny it? So,
like it's been said, on a water gathering facility, the lines are tied to be the final destination is to be disposed of, whereas this gas gathering line is for sale, and the primary purpose is really the reason.
What did you have any interaction with DEQ when this transfer responsibility was transferred over to DOGM?
Not really.
Okay, so
we didn't have a lot of information. It's just been a case-by-case basis that we've been doing it.
Would we have any knowledge then of how they've treated gathering systems in the past, other than shrugging and not?
No.
Okay. Okay.
So why why are we hearing this so late in the game? Why is it happening now versus 3 or 4 years ago? Well, I guess it wouldn't have been us 3 or 4 years ago. Why is it being brought now?
My understanding is that XCL, Mr. Dalton looked at it and said, hey, this is a pollution control item, realized there was a sales tax exemption in Utah, reached out to me and said, what do you think? Is this pollution control equipment under Utah law? I said, yes, you should apply. They did. And then it took a while with, the 2 witnesses here, and they did we really appreciate all the good work they do, not just on this, but on other things. It's been a really good, healthy, cooperative relationship with the oil and gas industry. And I've been working with DEQ for years, and these guys reviewed it, and that took a few months. But so I can't remember when the original application came in, but it was probably a year ago or so. But it was basically just because they didn't know there was an exemption available. They looked at it, figured out there was, asked me my opinion, and then they brought it.
Okay, thank you.
Anybody else have questions? Okay, so we're looking about $300,000 tax refund. Or you've already paid taxes on this stuff, or?
Yeah, we paid the tax, and that's the way almost all pollution control works, because the certification process has often taken a while with DEQ. DOGM, I think, has been, well, I can't say one way or another, but DEQ, it's always taken a while. And so most taxpayers pay the tax, then we go in, get the certification, then we go in and get a refund from the tax commission, but we can't get that refund from the tax commission until we have the certification from DEQ or DOGM.
Okay. Let me clarify one thing with you, Mr. Haynes. The exemption on flaring is 1,800 MCF per well
Per month.
per month. Okay, so about 60 MCF a day. Okay, thank you. Mr. Wallace, in your 8 years here, how many gathering system issues have you had to deal with? How many permitting issues for gathering systems have you had to deal with?
So normally we, when we permit wells, we don't really look at gathering systems when we do that. So once we I permit stuff that deals with locations itself.
Okay.
And so anything on that location, then I would take a look at. Anything that leaves location, normally those type of things, those lines and stuff, we'd basically under, that would be between the operator and the landowner, whoever would take care of anything as far as lines leaving the location. Now, if there was a spill or anything like that, then DEQ would be over that once it left that location. So that would be in their wheelhouse, not ours. But as far as gathering lines, I can't answer that question because I've never had to permit one. Of just.
Okay.
You could also ask if any other companies have asked for exceptions to the flaring rules too.
Mm-hmm. Yeah. Okay, so who regulates gathering systems then? Are they just, within the company? This is a company-owned gathering system. Who regulates it once it goes off the pad to their central processing facilities?
Normally, it would be like Kinder Morgan or one of them that would take it away from that point. Kinder Morgan or Williams.
Okay.
Or it'd be the operator, because I've worked on several more. The operator was the owner of that until it hit the Kinder Morgan line, and then at that point, but it's generally Kinder Morgan or Williams.
So, Mr. Wallace, Does the division inspect gathering systems periodically?
No, we do not have any rules for gathering systems to inspect
No
them.
rules. And so if a gathering system changes ownership, there is no concern of the division or no approval or anything as far as that goes?
As far as gathering systems, no, but I know DEQ has their hand in it. I don't know how far. I can't answer that honestly of where they're at in that, but DEQ, I know does a lot of those pipeline stuff, things,
So I guess this question's for Mr. Haynes. So then, now that we have this authority, and the first time that the division's actually going to address gathering systems is when somebody comes in and asks for tax exemption, and they've not been tracking this thing from its inception at all. Is that accurate?
I'm not sure I understand your
Okay.
question. Sorry.
Let me rephrase that. Okay. So obviously we're regulating the APDs and all that stuff, and in fact we regulate flaring. But between that time that's done and then the gas and oil gets over to a facility where it's then going to go into the interstate pipelines or into Kinder Morgan or Williams. Yep. The first time we touch the thing that connects it to that is when somebody comes and asks for a tax exemption. Would we have any knowledge of this thing before then? The design or the purpose, or
yeah, I don't have an answer for you off the top of my head. I mean, we regulate oil and gas. We also regulate transportation. There may be somebody in this room that's more knowledgeable than me on this, but gas gathering lines, my take is, they're contractual. You need your right of way in there. You need your agreements in place. We don't touch that.
So
You do regulate like the flaring on a compressor station, though, right?
Yeah, we can. Yep.
Yeah. So what's your limits on a compressor station? Is that a oil well, or is that a?
So we don't. I mean, we do the flaring on it. I know in the past, just as an inspector, DEQ takes care of most of the stuff, or air quality would. DAQ would take care of most of the stuff at those gas gathering places there. I know we don't have specific rules what we would regulate there. I'm not sure if that's in the works. I can't remember. But I know that we were working on some stuff, working towards that way. So yeah, as far as those, the only thing we regulate is the gas flaring on that. And normally, we're getting nuisance calls when them are going on, and so we go and make sure that they have a permit from oil, gas, and mining to be able to flare that amount of gas.
So on the gathering systems, if they're not regulated by anybody else but division, is that true?
You mean like oil and gas, the gathering line itself?
Well, the gathering system itself, can multiple operators put into the same gathering system? Does anybody oversee that?
I don't know. Normally, the gathering system is for the wells for that gas to be sold from those locations. That's what that gathering line for is to gather that gas to be able to go down line to be sold. So I don't know. I can't answer that honestly myself.
So,
Go ahead, Greg.
if I'm following correctly, we start produce gas. If there's not enough gas for it economic, you flare it. If flaring is too high, then you try to sell it to Kinder Morgan or whoever it is. And then, but in this situation, you had enough wells, you were making too much gas, and you could sell it to Kinder Morgan, but the rest of it is going in excess again anyways. But none of that gathering line is regulated by DOGM. It's only when looking for a tax exemption that it,
Yeah.
Well, I mean, when we use the term regulate, that means we don't have rules on it, right?
Yeah.
But the board, by statute, has jurisdiction and the ability to make orders over many aspects of oil and gas that we don't have specific rules on. I don't know if that helps answer your question. I mean, I can read you. It says the board shall make rules and orders necessary to administer the following provisions: ownership of all facilities for the production, storage, treatment, transportation, refining, or processing of oil and gas shall be identified. So we have some ability there. And that's really, I mean, I don't want to get into the weeds too much, but that is why we are here today and not at DEQ.
well, it almost seems like you mentioned rulemaking. It's like he's, in one way, I'm not saying we do this.
Yeah.
But it seems like you go to rulemaking to regulate gathering lines. But,
That is a whole nother issue.
I know, that's what I mean.
So yeah, primary purpose is what we're trying to figure out here. And I'm trying to think of another question that would help us decide whether the primary purpose was to prevent pollution, or is it to prevent waste and for natural gas and for sales. And yeah, just wanted to give all of you an opportunity to make your argument one last time. That, not asking more close, I don't know. Anyway. Anything you want to say that would help convince us that that was the primary purpose versus what they're saying?
Absolutely. I will just quote their response. The primary purpose of the pipeline equipment was to comply with waste regulations. And I'll quote what Mr. Haynes said just a minute ago. Not flaring prevents air pollution. And he also said that flaring creates waste, and so not flaring prevents air pollution, so flaring creates air pollution. So therefore, if you're not flaring and wasting it out into the atmosphere, you are preventing air pollution. That's the whole purpose of this, and that is the primary purpose of what we did. And how did, the DEQ's been looking at this for years, and like I said, pre-2012, they had one simple test. The statute was broadened in 2012 to make it clear that if you voluntarily did it, it was also satisfactory. But the test was this required by a DEQ order? And in this case, this clearly was required by a DOGM rule. The whole reason they put this line in was because DOGM's rule says you can't flare. Otherwise, they'd have just flared. But for their moral compass that they talked about, but otherwise they'd have just flared this. But because of the DOGM rule, they said, no, we have to spend this $50 million so we can keep operating. So it's a pretty simple, straightforward analysis of, was this mandated by the government? Therefore, the 1973 legislature said, we shouldn't put a 7% tax on top of this because it was mandated by the government and they had to spend all this money to comply with the anti-flaring rule. A couple of other quick points. Number one, it's not going to open Pandora's box. This is very rare. I think the reason you haven't seen it before is because it's probably highly unusual. Somebody's producing enough that they go over and above those allocations of Kinder Morgan or Williams. Usually I think people can find a place to get their gas on the interstate pipeline. But where they had so much that it wasn't allowed within those allocations, they had to find a place to put it. They didn't want to shut in their wells, so they just kept producing, and then because they couldn't flare, they built this gas line for $50 million. And kept it going, but it's not Pandora's box. There's a reason you're not getting inundated with these requests because it's highly unusual. I haven't ever heard of it before. We may never hear of it again. This might be the only circumstance where this actually happens. I don't know. I don't know the answer to that, but just the fact that you haven't seen it, DEQ hasn't seen it, these guys haven't seen it, I haven't seen it, and I've been practicing in this area for 30 years, suggests it's probably a pretty unusual circumstance when the anti-flaring rules cause somebody to build a gas pipeline like this. And then...
No, I think we're going to see a few of them if we grant this. So
yeah,
it is opening Pandora's box, but here we are.
If they call me and ask me, I'm going to ask them the same questions I asked these guys. Why'd you do it? Was it because of the anti-flaring regulations, or are you doing this to generate a profit like most every gas pipeline does? You know, people are out there building gas pipelines every day because they want a return on their investment. They want a return of their investment. They're going to make money. That's what makes the economic circle go. And there's all kinds of pipelines that do. This one, it's not one of them, which is why I told them I would make the application, because this feels and smells to me just like the low NOx burners in a power plant, just like the solar pumps in a gas field, just like the water disposal lines in an oil and gas field. You still make money in those fields, but you make less money because the government makes you do something to prevent air or water pollution. That's the definition of preventing air or water pollution.
Okay. Do the water disposal lines come back to us for recognition whether they are tax exempt or not?
Yes, if they're tied to a water pollution control facility, they can be included.
And are they generally included?
Yes.
Okay. And can you, in your workings, can you draw a distinction, or can somebody educate me on your ideas on whether the company, say XCL, is going from their well sites to their central processing facility, and then what Kinder Morgan or Williams or another party that's clearly taken to interstate commerce, do you guys see those definitions clearly? Can you sense those in your deliberations on what should be tax exempt and what shouldn't be?
I mean, that's hard to answer. We just saw it as a gas sales line.
Mm-hmm. Okay.
Could you remind me when this pollution control tax act went into effect again, the year that went into effect?
As far as the division taking over, 2024.
2024. And when was the asset sold?
October 2024.
Okay, so right now you're asking for this exemption on an asset you don't own right now.
Correct, which is pretty typical in the oil and gas fields. These things change hands quite often. They extended the statute of limitations on pollution control from 3 years, which is what it is for every other sales tax exemption, to 6 years, knowing that it would take a lot of time to get these things certified by the DEQ and now DOGM. So this is pretty normal in my experience.
Mm-hmm. Wow. Okay. Yeah, go ahead. Well, we still need to go to closing arguments too.
Yeah. Just I know that we had, the discussion was earlier, but just so that it's more clear in my mind. So you sold the asset, and the pipeline was part of the sale of that asset?
Yes.
Did the company recoup all of the $50+ million that they spent?
The witness testified that they just got one lump sum amount for the entire thing, and
there's no breakdown
he didn't have a breakdown for the various components or assets of it. But as I indicated, every economic enterprise out there has value and makes money. But when you have pollution control, it makes less money and has less value than it otherwise would have.
So wouldn't the company that acquired the asset qualify for since they purchased the asset, wouldn't they qualify for the tax exemption if the tax exemption was approved?
Only if they paid sales tax, and because that's what we call an isolated and occasional sale. If you come in and buy all the assets of another business, then that's an isolated or occasional sale. That's not subject to sales tax in the first place. So there was no sales tax paid when XCL sold it to SM. The only reason we're here is because XCL had to pay sales tax when they spent this $56 million to build this pipeline. They had to pay sales tax on all those purchases of pipe and whatever else. And so that's the only time this would ever be subject to sales taxes, on that original purchase. It could be resold 50 times and there would never be another sales taxable event.
Okay.
I think somebody else down here had a question. Okay. Any more? Okay, so let's go to closing then, please. Okay.
I just basically made my closing, but I'll just reiterate a couple of points. The state's witness indicated that they denied this because the gas was for sale. But that not all gas pipelines are created equal. Yes, many, probably most gas pipelines don't qualify because gas is for sale, and it's not the primary purpose to prevent air pollution that gas pipeline was built. This one is. It's the only one I've seen. Maybe there will be somebody else that comes forward and asks on the same basic facts. If they do, they should get the exemption, because the primary purpose for which they would purchase their pipeline, if the facts are the same as these, is the prevention of air pollution. And the division agreed with us when they said the primary purpose of the pipeline equipment was to comply with waste regulations. That is exactly our point. We agree with that. And that is the prevention of air pollution, and therefore this qualifies. And we think it's a pretty simple, straightforward analysis.
Okay, Mr. Haynes?
Thank you. As indicated, we were here to present to the board our understanding of the Pollution Control Act and our role in certification there. And I just wanted to make it clear, again, the issue we have is with the definition of freestanding pollution control equipment, and it has to have a primary purpose, okay? But in saying that, equipment can have many purposes. Mm-hmm. Property that serves pollution control as its chief function, even if it also operates or provides some operational benefit, would satisfy the primary purpose requirement. But property acquired primarily for production or sales or operation efficiency that happens to reduce pollution as a byproduct would not. In the instant case, we have many gas lines that were indicated they were installed for gas gathering, and they were moved into the sale of commerce. And these gas sales were made, it was indicated, to avoid flaring. Well, flaring is, as we talked about, it's 1,800 MCF per well, which is not a lot of gas. But the sale amounts, we were told, were much, much higher. So again, you have to ask yourself, was this the primary purpose of these lines? Gas sales with the ancillary benefit of pollution control? Or were these just for pollution control and there was a small benefit of some of these gas sales? And this is, I'm laying this out for you because this is the same question we had to ask ourselves when we were looking at this. And so with that, I've given you the division's position. We're not here to be combative or argumentative over this issue. We're just here to explain where we stand on this issue. So thank you.
Yeah. I don't think we're being combative either. We're just trying to figure it out. How you guys, the first time you touch a gathering system is when they come in and ask for tax exemption. That doesn't seem like the right time to start having jurisdiction over something. But anyway, in my mind. Board, do we have any other questions? I think we're going to have to go deliberate on this for a little bit. What is it, 2?
At least 20 minutes.
Half an hour? So come back at 2:30? Oh, wait a minute, which watch? Yeah, let's come back at 2:30 and we'll see if we can wrap this up. Thank you.
Thank you.
Thank you, everybody. We're back on the record, and we're here to finalize our discussions on agenda item number 6, which is docket number 202639, cause number 139-175. And before we talk about this, the board wants to express its appreciation to XCL and to Holland and Hart for bringing this matter before us gave us a lot to talk about, a lot to think about, and we certainly appreciate everything that DOGM did in educating us on what this issue involves. So with that, take a motion. Oh, sorry.
I'll make a
Just quickly, well,
Okay.
just to go along with what Al was saying, and I would like to just mention all the good that XCL did for the basin while you were here. You pioneered horizontal wells. You became the #1 producer. Just really appreciative of all you did while you were in Utah. So come back anytime.
Make a motion.
Go ahead, we'll entertain a motion.
I'll make a motion that we deny the request for agency action to certify the equipment as a pollution control facility.
Motion's been made and seconded to deny the request for agency action. All those in favor say aye.
Aye.
Any opposed? Okay, the request for agency action is denied. Board counsel will write the order, and we'll have some explanations within that order. And we do, again, really appreciate Holland and Hart and XCL bringing this topic before us. I don't think this is the last we've heard about this, so we'll hear more, sure. Thank you. With that, entertain a motion to adjourn.
Motion to adjourn.
Okay.
Second.
All those in favor of adjourning, say aye. Aye. Any opposed? Say nay. Okay, thank you very much. We are off the record.